I'm Natalia Oakes. I'm the judge of the 313th Juvenile District Court.
And then I'm Leah Shapiro, and I am the judge of the 315th District Court.
And I'm thinking about this. I thought this is a good time with a captured audience to tell y'all a few things. First, I'll start, even though I know this isn't a CPS CLE, I do have something on my mind about the vouchers for CPS in my court. The lawyers, please remember the hearings are $175. Some of y'all overcharge, some undercharge. It's $175. The trials are $350, and the out-of-court hours are $100. And it's really helpful if you write them in yourself and just get the right amounts, so I don't have to get out my red pencil and correct it. And as far as out-of-court hours, which drive us up a wall, try not to spend, when you review a permanency report for half an hour, it's really, unless it's a 30-page report, every report can't be that long. So try to be reasonable, like a quarter of an hour. And as for juvenile court, please remember to give your juveniles a school excuse and ask them if they know what to do with it, where to take it. You really have to walk them through this. And ask the parents if they need a work excuse. Try to stay up to date with probation programs because they're changing all the time. And truly, as a judge, I hardly know the kid, and the lawyer knows the child a little bit more, but no one knows as well as the probation department. So they are there to tell you what services the court liaison of the probation department is there, and if you tell them what the needs are, they can tell you some extra programs that maybe you can put on the recommendation, because the DA doesn't know the child either. So that's helpful. Please be mindful of the parents' working times to if you reset needlessly, it's really a burden on them. And the general etiquette of the juvenile court is to give the clients a quick grooming and etiquette lesson, to say no ma'am, no sir, pull their pants up, tuck their shirt in, stand up straight, and, take their earrings out. I think the parents appreciate it when you tell them that. And other than that, I have pretty good communication with the lawyers and the people in my court. So, feel free to ask me anything if you need clarification. Thank you.
Did you mention MAC or no? Okay. Hi. Sorry. I'll go this way. I'll switch it up. Okay. Is that better? Okay. So just a few things that are going on with all three of us. I know there's been a lot of chatter about the appointments exam, and I just wanted to kind of clear up any information or confusion or questions that you guys have about it. We will be doing an exam that all attorneys will have to take in order to be eligible for appointments moving forward. We're going to mirror the felony system and the misdemeanor system. The dates for that exam are going to be out as soon as we can determine them, but the application will also be available online in short order. If you've previously applied, they do have your application online, and you will just have to supplement what is there if necessary. Or we've actually seen the sample application. It's really easy, and so hopefully it'll just take you less than 10 minutes. But that's kind of where we are with that. So as soon as we know those dates, we will get those to you as quickly as possible. This free CLE was just to make sure that everybody was good on their CLE to be eligible to be able to take that exam, and then we will do the ballot again just like they've done in years past. One of the other things that we wanted to we're working on right now, especially I think the 315th will probably be the first court to implement it, is the restraints and shackling. Right now, currently, Harris County indiscriminately restrains and shackles all children who come through the juvenile justice system who are in the detention center. We are working diligently with the sheriff's office, with the DA's office, with probation and defense counsel to amend and give each of those kids an opportunity to participate in courtroom proceedings, hearings without restraints and shackling. So that is something that we are, yeah, it's great. And so we are working very hard on that. We have had a lot of meetings and protocols. And if you are curious to hear more about that, I'm more than happy to explain to you where we are. But it has been a collaborative effort, and the safety of the courtroom and the kids and the families is obviously paramount. But we are very, very excited about that. And I think that right now we can open it up to questions. If anybody has anything that they are pressing or confused about, we will, yes. No, that's correct, because you've proven your proficiency. I mean, again, this is just to create a standard, and just it will be open book, open notes, just like the adult exams are. And this is, again, it's just a proficiency exam. It is to just making sure that everybody has the fundamental grasp of what we're doing here.
So you don't have to take it if you're board certified.
In juvenile law, correct.
Thank you.
Any additional questions? No? Very easy. Yes.
Are there going to be, is it only going to be only on specific days that the exams will be taken, or will there be a broad range where options can be?
Well, this is one of the things that we are discussing right now. We're going to try and get one in the end of May, because I know that people go on vacations. The summers get a little tricky. And so we are going to offer it for many dates. And one of the things we were discussing, if Thursdays are best, Fridays are best, but it also is dependent upon the monitors and the space available. And when you guys submit your application or supplement your application and sign up for the exam, that information will then, you will be part of a list where all the most up-to-date information will be distributed. Any other? Which part? The signing up? Yes. Yeah. I believe that's correct. Yeah. Any other questions? Okay, you guys are really easy. I feel like this is unnaturally quiet, but yes. Yeah, so right now, if you go to the Just Text website, on there under the FDAMs, there's a link to FDAMs. It will be the current application is available. The board just amended, we just got approval from the juvenile board to change some of the standards for eligibility under A, B, and C. And those updates will be submitted and provided as soon as pretty much as we can type them up and get them online, so that you will know the language that was amended, and Ms. Oakes can speak to it, actually broadened the standards. So if you want to talk about that.
Well, before the standards were like a catch-22. You can't practice in juvenile court till you have a certain amount of cases, and you can't get those cases unless you practice in juvenile court. So now it's opened up for more adult criminal lawyers to show their experience and document the things they've done to qualify to be an A attorney, which is capital murder and first-degree felonies, and second-degree felonies. And then B, we have state jail felonies. And then C, the qualifications really haven't changed. It's just kind of to get your foot in and get some practice. So I think it just broadens.
Mm-hmm. Okay, any other questions?
One.
Yes.
This is one trying to get in right now and apply tomorrow or today. They'll have to wait until after the exam and get in after that.
Yes. So his question was, if someone wanted to go and apply today, would they have to wait? Yes, because the way that the ballot and the voting process works, it's just for efficiency purposes. We're going to wait until after the exam to do the ballot. Yes. Anything else? Okay. All right. So we'll give you guys some time back. Thank you. And thank you all for attending. This is a fantastic turnout, and we are very, very excited. So thank y'all.
Okay, our next speaker, Jerry Michael Acosta. Jerry is a native Houstonian and a proud graduate of St. Thomas High School, where he was a stud football player. He's still waiting. He's waiting to get a phone call from the NFL draft, see if he gets taken in round 2 today. Jerry received his Bachelor of Arts in Speech Communications from Trinity University in San Antonio, Mark Castilla's hometown. In 1999, he received his Juris Doctorate from South Texas College of Law Houston, in 2003. He was admitted to the Texas State Bar. He began practicing under the tutelage of his father, you all know, Jerry Acosta Sr., and he worked at the law offices of Geraldo Acosta. Actually was interning there since the age of 16, when Dad taught him how to cash a check and how to collect money. He's been doing that. In 2012, he opened his own law practice, Jerry Michael Acosta and Associates. Very nice. And primarily represents juveniles and adults in delinquency and criminal matters. In 2015 and 16, he was named a Rising Star in Criminal Defense by Texas Super Lawyers. And from 2017 to 2019, he was named a super lawyer by the same publication. Now, this last line is the biggest shocker for anybody that's known Jerry as long as I've known him. He and his wife, Kathy. Let's just stop there and think about that for a second. Many people in this room never thought Jerry would ever have a wife. He and his wife, Kathy, live in Houston with their 2-year-old son, Cruz Michael, and, of course, their dog, Austin. Man, who would think this guy would have ever settled down? He's a favorite in the courthouse, Jerry Michael Acosta.
I was trying to dodge.
You said he settled down.
Yeah, right. I was trying to dodge, but I got picked up on a writ, and I have to come back and give this speech on detention hearings and risk assessment. People that know me really well know that I don't like public speaking unless there's alcohol involved, which there's not this year. And, yeah, exactly. The last time I was in front of this many people with a microphone was at karaoke night last night. But I digress. When I was asked to volunteer to speak at this conference, there were still topics left on the table, and I was there, and I had my option of what to pick. I saw certification Determinate. I'm like, nope, that's pretty complicated. I saw fitness to proceed was still there. I'm like, no way. Hans is a saint. And I saw detention hearings, and I was like, yeah, I could do that. I mean, on average, detention hearings probably last like 2 minutes. So I'm like, I'm in. And the judges were like, you'd be good at that. You've got a lot of experience. Like Steve said, my experience is more getting out of the doghouse. But if you think about it, you're trying to get out of a place where you really don't want to be for allegedly doing something you're not supposed to do. But it's not just the hearing. There's many components involved with a detention hearing. And it's really, there's a lot of things that go into what will ultimately decide whether a child will be detained or not. And so what I've done in this presentation is I've attempted to explain the process from when a child is referred to the juvenile court, and all the opportunities he or she has to go home, because ultimately that's really all they want. And I've been told that that not everybody can see the slides, so I'm going to go ahead and read mine. Okay. But first, how does the Texas Family Code address juvenile detention? Slide 1. Okay, the Texas Family Code provides for issuance of a warning notice in lieu of taking the child into custody, authorizes release by police by child taken into custody on the condition that the child be brought to the juvenile court by his or her parents or other responsible adults, permits administrative release of a detained child by intake or other court workers, and creates the right of a detention hearing before a juvenile court judge, referee, master, or detention magistrate. So you've got 4 scenarios. You've got the catch and release that does not exist in Harris County at this point. You've got release at the station after a conversation with the police department, between the police department and juvenile intake. You have the administrative release that occurs after the child's brought to the juvenile detention center by intake, and then you actually have a hearing. So there's a lot of factors in play that don't even involve a hearing, and that's why this is called detention hearings and risk assessment. So Perry Joe went over a lot of this stuff as far as how the process works in Harris County, how a juvenile may be referred to the juvenile court only if probable cause is established by the DA. It's typically done by a telephone call. Bring the child to the station, make the entries into the JOT system, APHIS, SO numbers, and then there you go. So then there's a conversation between, well, before I get to that, I made a very nice flow chart. So this is how it works. The child allegedly engages, there's a police investigation, DA finds PC, and then the child's brought to the station. And at that point, the child can be released without conditions of release at all. They're just responsible adult. Or the child's brought to intake where the RAI, the MACI, the pre-PAC interview, an interview with parent occurs, and I'll go in all those into detail later. They can be released there with conditions of release and no supervision. Released with supervision by the Juvenile Probation Department, and released on PAT release, and I'll discuss all those. If they're not released at intake, well, then they have a detention hearing. You have your initial detention hearing, which I'll go through all this. This is just kind of a walkthrough of how this presentation will go. But at a detention hearing, you can get released with those same release conditions. If you're not, well, then you're going to have a district court. You can go have a detention hearing there, and then every 10 working days thereafter, or discretionary anytime you want. So, who can release a juvenile under the Texas Family Code? The police, juvenile intake, or a judicial officer. Police release at station of juveniles at police station. Section 5202A1 authorizes a police officer or other person who's responsible enough to bring the child back. In Harris County, police have decided that the matter needs to be referred. They get on the phone with intake. They call intake, and there's a whole division of probation intake officers. And they go through their categories of why a child should be released, and they make the decision there. And if not, they're brought to intake for further investigation. If a case is referred to juvenile court and the child is not released by the police, the child must be physically taken to the detention facility designated by the juvenile board. Guess what? We're in it. It's right across the hall. There's 5 stories. They're detaining a lot less people, so this is the only facility that exists that has kids in detention right now. At that point, the responsibility falls on intake and probation officers. So probation has a lot of pull, basically, on whether or not a child has all the pull, really, to make the decision as to whether or not a child is going to be released or have a detention hearing. The presumption under the Texas Family Code is in favor of release. Section 5302A requires a juvenile be released unless one of 6 circumstances exists. And I'm going to show you that slide right now. Catch up. So these are a lot like the conditions that are the conditions that a judge looks at a detention hearing. They're identical, basically. But the child shall be removed unless the child is likely to abscond or be removed from the jurisdiction of the court. Suitable supervision, care, or protection for the child is not being provided by a parent, guardian, custodian, or other person. The child has no parent, guardian, custodian, or other person able to return the child to the court when required. The child may be dangerous to himself or others. The child has previously been found delinquent or has been previously convicted of a penal offense punishable by a term in jail and is likely, it's a two-pronged deal, is likely to commit an offense if released. And then there's F. The detention is required under subsection F. This sounds like a test question. Okay, firearms offenses. A child who is alleged to have engaged in delinquent conduct that involves the use and possession or exhibition of a firearm in the commission of the offense must be detained until released by the direction of a judge. So when intake gets these types of cases, they have no authority to make that independent decision themselves. They're going to have to either get on the phone with the judge and get released that way. Otherwise, the child's going to have a detention hearing. Any judicial officer may authorize intake, whether it be a referee, whether it be a magistrate, whether it be an associate judge or an elected judge, but it has to be by a judge. So what happens at intake? Calls to the attorney if they have one, but that rarely happens because a child's not appointed an attorney until they're detained and they have the detention hearing. It's not a lot of kids that have their lawyer's business card in their wallet that they met at a cocktail party or something at Christmas. But there's calls to parents, and there's an interview there. There's the RAI pre-pack, the Macy or the Massey, depending on what side of town you grew up on. Interview with the parent, and then so it's at this point that intake collects as much information that they can. This will serve as the foundation and groundwork for managing the youth in the judicial system. So I'm going to go through all these, right? The RAI, the pre-pack, and the Macy. Okay, what is the RAI? The RAI is a risk assessment instrument. It's used on the phone by Harris County Probation by the intake officer when they're discussing whether the child should be released with a law enforcement agency. An intake determines whether the child may be released or must be detained based on an aggregate score, mandatory detentions, and overrides. So I provided one of the risk assessment sheets. So it's basically, it's like a score chart. And so at the end of the day, if it's a low risk, they're going to release without supervision. Mind you, this all happens at intake when they're not released at the police station. A condition release, which is the tracker, or they're going to have a detention hearing. They're going to have to detain. So if you look, they look at the most serious alleged offense, additional charges, their history, their delinquency history or criminal history, pending petitions, and the history of failure to appear. That's their likelihood to return to court. So there are some mandatory detention situations. If there's an active warrant, that happens quite a bit, and as well as the firearm. That sounds like a test question. Okay, and there's overrides as well. Like let's say you're a 15 and you're supposed to stay, but they've talked to their parents, they've talked to people, guardians that can provide suitable supervision. Well, they can override. Intake has like a hierarchy. There's Miss Tillis at top, and there's several intake supervisors, and then there's intake workers. Intake makes a call. A supervisor can override, but Miss Tillis has the last say, and I provided her information at the end of this presentation. Okay, the Macy. This happens in intake as well. The child's brought in, and they do a screening. It's a screening instrument designed to identify potential mental health needs of the adolescents involved in the juvenile justice system. So this is where they're not trying to focus on really their criminology or criminogenic needs, but more their mental health needs. And this may be done more than once because, if a kid's detained, his mental health needs may change. This is more messy stuff. It is available in English and Spanish, and that's a good thing. The pre-packed. Someone's going to talk about pre-packed tomorrow. Susan or Rynders, she'll probably hit a lot of this information. But it's basically an assessment that was developed to assist judicial probation officers in determining a youth's level of risk to reoffend. This is the criminogenic needs, and they start making up an intervention plan to get these kids some help there. These are the questions that they ask. Basically, records of referral, questions about school, their peer relationships, family history, alcohol and drugs, and mental health. This might be out of place, which would make sense, but this is an example of an RAI where the kid's a low score. You can see he's a 7, but there's an active warrant, so it's an automatic override. Okay, so what happens if the child's released? What types of release are there? Release from intake with conditions. Release of a juvenile may be conditioned on requirements reasonably necessary to ensure the child's appearance at a later court proceeding. If the child is released to an adult, the release must be conditioned on an agreement that the adult will ensure the appearance of a child at a later court date or be subject to an order of contempt, and these conditions must be in writing. In Harris County, intake may release a child with conditions of release. There's no supervision by the Juvenile Probation Department on a condition of release. And basically, it's just don't do anything stupid, but it has to be in writing per the family code. And basically, this is what they have to sign. It's don't use drugs, don't break the law, go to a court when you're supposed to. You're going to be subjected to RUAs, and you're not to have any contact with your co-actors. And whatever else Pat deems necessary. Or not Pat, but intake deems necessary at that point. So tracker release. I think a lot of people ask for tracker release without really knowing what it is. But it's a 30-day program where there is a advocacy program involved. It's called the Harris County Advocacy Program, HCAP. And basically a specific mentor monitors the kid every day, can even go to their house on Sundays. And it's a community partnership. If you have any questions, contact Probation Department, Israel Mustafa. He's in charge of the tracker program. Next type of release is a PAT release, the pre-adjudication team. It's basically where you're kind of on a probation without being on a probation. There's home detention. The child may not leave the home or place of placement without constant supervision of approved adult unless it's in school or approved verified job. You report to an assigned PAT officer, and the PAT officer monitors the youth's behavior, could even show up at their school. RUAs, no contacts. This was interesting in doing some research. There's currently 9 PAT officers, 156 children that are on PAT, and 85% are violent offenders. This is something you would want to ask for an aggravated robbery or first-degree felony. This is another form that I have for you that basically gives all the roles that I just explained. Ankle monitors. Everybody asks for ankle monitors whenever they are trying to get their kids released. It's like the Holy Grail, right? There's 44 ankle monitors available to the Harris County Juvenile Probation Department. It's only for people on PAT. It's free to respondents. Back in the day, you had to pay for it. But now you only have to pay for it if you rip it off. But you'd have to pay, and there's a $25 fee for charger, $450 fee for the ankle monitor itself. But it's pretty good. They use them across the street in adult court. I could pinpoint the respondent's location at all times. Pat, this is interesting too. Pat will ask for removal after 30 days, but the attorney can ask for removal anytime. That's the ankle monitor. Oh, it's $500. My bad. Okay, so if they're not released, intake has to request for a detention hearing. So what's the time frame on that? If an intake officer does not release a juvenile from detention, or if release is not an option because a firearm was used, that sounds like a test question, or exhibited during the commission of the offense, the family code requires that a request for detention hearing may be made promptly, must be made, but not later than the second working day after the child is taken into custody, provided, however, that when a child is detained on a Friday or Saturday, then such detention hearings shall be held on the first working day after the child is taken into custody. This is bad when, like, you get detained on a Thursday, you get the short end of the stick because you got to wait till Monday. That's like 4 days. Okay, detention court. That's downstairs right here, right across the street. Section 5401 creates a right to a detention hearing before a juvenile court judge. The juvenile board has the authority to appoint a referee or master or detention magistrate to conduct detention hearings, and the initial determination is really a recommendation to the district judge, and that district judge has the power to accept it or reject it. I think Samantha Davis is here, right? That's you, right? How are you? Let's see here. Okay, criteria for statutory release, it's the same as 5402 or 5302. The likelihood to return to court, be removed from the jurisdiction. Supervision plan, there's no parent available to bring the child back to court or give proper supervision. They may be a danger to themselves or others if they're released. And then the history, if they've been, the two-part again, been found prior to be delinquent and is likely to commit an offense if released. There's a privilege against self-incrimination in detention hearings. Section 5401B requires the court to inform the parties of the child's right to remain silent with respect to any allegations of delinquent conduct. Conduct in eating chins or sins, or conduct that violates an order of probation by a juvenile court. No statement of the child made at a detention hearing shall be admissible against that child at any other hearing. So the effect is, child has a right not to speak at the detention hearing, but if they choose to, it can't be used for any other purpose other than to detain them or not. Admissible evidence in a detention hearing. The court may consider written reports from probation officers, professional court employees, or professional consultants in addition to the testimony of witnesses. Harris County uses a probation report. A copy of the report must be furnished to the child's attorney before the hearing begins. All the RAI, the Macy information, the pre-pack is going to be there, and you're going to be able to use that as your information to argue why the merits of why your child or your client should be released, and vice versa for the district attorney. Records in detention hearings. Upon request of any party, a detention hearing shall be recorded. An audio tape recording is sufficient. Subsequent but initial detention hearing can be conducted by two-way television. They used to do that more often when they were detaining more kids at BBRC. The use of this technique requires constant consent of the child and the child's attorney, and the record must be preserved. Okay, the mechanics of a hearing. It's typically a short proceeding. The state has the burden. You can proffer your evidence. You can provide testimony. The child has a right to an attorney. The child normally doesn't testify. I instruct my clients never to say anything, really. An ad litem could be appointed if there's no parent or guardian present. The child's attorney argues for release, and the state argues for detention. Detention hearing and probable cause. We're in court downstairs a lot, and the referee down there is constantly hearing probable cause whenever there's not a hearing. And this is a different kind of probable cause. This is not the DA probable cause, where they have where DA finds probable cause to refer the juvenile to court, but the Fourth Amendment type that would allow the child, I guess, to remain detained. It has to be made within 48 hours of detention. It's non-adversarial. Child does not have a right to confront and cross-examine witnesses, and it can be based on any reliable evidence. And usually, it's the information available to the prosecutor at the time. A post-custody judicial determination of probable cause is not required when the child is arrested under directive to apprehend issued by the judge under Section 5205. A referee typically makes a determination of probable cause. It's just a recommendation, and the district judge has the power to accept it or reject it. Judicial findings of probable cause need not be made in a hearing. Often there's not a hearing, like I said. Typically, the referee is sitting there listening to the district attorney. District attorney is just reading what's in their jots or the Justice Information Management System. And the judge can or cannot find probable cause. Waivers. A child's initial detention hearing cannot be waived. Detention hearing order extends the child's confinement for no more than 10 working days. Subsequent detention hearings may be waived as long as the waiver is in accordance with the requirements of 5109. The maximum life of 10 working days for a detention order provides the parties a means to get before a judge or referee new evidence or changed circumstances which may bear on the detention issue. Okay, so preparation for the hearing. This is what I recommend. Meet with all the players as soon as possible. Don't just go up there and like, hey, what's your plan of supervision, Mom? What's your plan of supervision, Dad? Meet with everybody, because you're going to get cases that are more difficult than others for kids that are detained. And you're going to need to be creative. You're going to need to create a plan of supervision that's going to fit and satisfy the judge that the child's not going to be a danger to himself or others, and all those other requirements required by the family code. Explain the process. It's not a hearing to decide whether you're guilty or not guilty. It's just a hearing to determine whether or not you're going to remain in detention until your next court date. Like I said, set up that supervisory plan. Where's the kid going to go to school? Who's going to transport the child to school, from school? Does he go to work? What are the parents' work schedules? Is there going to be constant supervision? And sometimes if the child's receiving some type of services like a mental health, they have like a psychiatrist or something that they're going to, that can't be provided while they're in detention, you can argue that they're not going to get the help that they need if they're detained, and that therefore they should be released if you have a good supervision plan. Change circumstances. I've had clients that have moved neighborhoods. They're in a neighborhood where their kid is getting in trouble all the time, and they decide to go to another neighborhood, and the child, it's a change circumstances, and the judge has to take that into consideration. And if at first you don't succeed, try again. Get the kid up in front of the child as much as possible so that the judge becomes familiar that the child's in detention. She or he will remember that, and it's pretty effective. Let's see. Okay, this is for post-18. This doesn't happen too often, but I figured I'd cover it. The Family Code provides special procedures for the detention of persons 18 years of age or older when proceedings are pending for certification to criminal court. It may also be on a transfer hearing too, on a determinate case. So those second and third criteria don't apply because there's no parent around. He's an adult. He or she is an adult. So the judge again has to release the defendant unless detention is justified by the statute of the first, the fourth, and fifth criteria. The judge at that point can set a bond or not, because the Juvenile Justice Code does not recognize a right to bail. It's actually silent on the subject. But in my experience, they've been setting bonds where in the past they weren't. And then finally, Perry Joe covered this. Whenever a kid's detained, the prosecutors have 15 to 30 working days, whether it's a felony or first-degree felony, aggravated controlled substance felony, or 15 days for the misdemeanors. And another thing I'd say is not wait 10 days, and to request a discretionary detention hearing. I mean, once you have your changed circumstances, get the kid in front of the judge as soon as possible. I've seen a lot of attorneys that just wait until the detention hearing or whatever. Just get them out as soon as possible. And I found that with juvenile justice reform, the kids are going to be less detained. Or detained at a lower rate, so let's get these kids out, I think that's it. These are my sources, maybe. Yeah, that's a hyperlink. I learned that that's a hyperlink. So that goes to the Harris County Juvenile Board's guidelines for law enforcement. Texas Family Code, Dustin. I mean, we're all talking the same thing. Also, John Mazel, the colonel. I cut and pasted a couple of things that he wrote here, Robert Thomas. But really, if you have any questions about anything, if you just call the probation department, they're super helpful. Nicole Tillis, she's the intake administrator. Darren O'Neill's the head of PAT. And Doris Cisneros, she's one of the detention court coordinators. They'll really point you in the right direction. And really, you could be effective if you get that call whenever the kid's brought to intake, and kind of, insert yourself in the whole process of when they're doing the RAI and all that stuff, and it's helpful for those kids. But I'll open it up to questions. No? Okay, we're good.
All right, the next speaker is Ryan Mitchell. He has his undergraduate degree in mechanical engineering from St. Clara University in 2002. He went to Hofstra University in 2005. After being admitted into the New York bar, he came down to Texas, became an assistant district attorney, and was assistant district attorney for 6 years, where he dressed much better when he was with our office.
I had Bill Hawkins as my chief at the time.
The funny story about Ryan as a prosecutor, there was a judge that didn't appreciate cross-examination. And depending on your tone, you know how when y'all do great cross-examinations, you just you're making statements and the person's agreeing with you, right? That's what y'all all do. Well, Ryan was doing that, and the judge wasn't understanding that concept. So she's like, would you please ask a question? So he said this statement, then says, question mark. That's in the record, right?
Yes.
I won't mention the judge.
You have to ask a question. I said it was, and she goes, well, it doesn't have a question mark at the end of it because she was reading it in real time and a quarter foot period. So when I asked the question again, I said question mark at the end, so it now had a question mark.
So y'all just thought he was a character on the defense side. He was a character with us as well.
Probably won't let me go.
He was fired shortly after that. Yeah. The influence of judges. What are you going to do? He opened up his own practice after those 6 years, and has primarily been concentrating on juvenile law, as y'all know from the courthouse. And I give you Ryan Mitchell.
Okay. I usually don't have a microphone, so if I get louder or softer, please let me know. I'm very upset at Jerry Michael because he was supposed to go for 20 more minutes longer than he was slated for. I'm just make it up. You didn't go over at all. 2, he stole my karaoke joke, as you heard before I came up here. And a couple of the other presenters have similar slides that I have, so if you see some stuff that's duplicated, I apologize. And most importantly, this presentation does prove that I do own more than one suit jacket. So y'all can now put the remedy. Y'all now know I have more than one. Unlike Jerry Michael, I found out my topic when I read the flyer for this exact CLE. And I said, oh, this is the topic that I get. So it's a combination of 3. It's certifications, determinate petitions, and transfer hearings. It's kind of good that these are kind of combined because when the prosecutors or the judges, the court system is trying to figure out how to deal with some of the juveniles, they're really looking at all 3 of these things at the same time. So it's real easy to put them all together into one presentation. Unfortunately, I thought that computer was going to be up here, so if I forget to change the slide, I apologize. So we're going to do this and just give you a little presentation roadmap of where we're going to go. The first topic we're going to talk about is certifications. Then we're going to move to the determinate petitions, and then since transfer hearings is a part of the determinate process, we'll end up on that. There is a paper that I jumbled together. It's not really a written paper, but it's a paper that I put with this PowerPoint. So if you get the Dropbox, please look at that. I wrote the determinate petition paper, so that was first. I did take some information from Jill Mata. She had some questions and answers back when Leonard Kukolo was the head of TJJD. She wrote some questions that you could hand out to certain prosecutors so that they could read through it to know what to ask, what elements to satisfy. So I added that in there. There's also a paper I've tried to write the certification paper, and it's never as good as what Cameron Johnson has already written. So he's already given me permission to put that out there a couple years ago. So I used it again because it's really, of all the papers I've seen on certifications, it's really the best one. So it's in there. And then there is, I usually put all the Cameron Moon cases there, but the file was too big, so I just put the first page. So if you do anything in this field of work and you haven't read Cameron Moon, that is a significant problem. So it really, not only did it create some new law and some law changes, but the examination of this whole process, it really lays it all out. It's a big read, but if you do practice in this field of work, you really need to have at least read that one time. So the cites are at the end of that paper. Let's see. So, where to find it. By the way, I'm experimenting on how to do PowerPoints. I've done PowerPoints a whole bunch of different ways, and then I made the mistake of going to some CLE onto how to effectively do a PowerPoint presentation. So we're trying something new here. They kind of, I guess, if you're ever going to do this as far as determinate or certifications, who here watches like The Daily Show or Stephen Colbert? Okay, so they basically what they say is, try to get a picture up there and then tie that picture into what your presentation is. Okay? So this one, certifications. Where to find it. So certifications is the law on it statutorily is in Texas Family Code 54.02. So your first place to go to is that. Now there are a couple of other places in 5402 that reference the Texas Human Resources Code. So a couple of times, if you're going through the statute on 54.02, you'll have to hit some of those. You'll have to have more than one book in front of you to get the full picture. But the first stop is 54.02. You're not going to see it titled certifications. It's officially called the Waiver of Jurisdiction and Discretionary Transfer to the Criminal Court. We call it certifications, but that's the official title of what it is. this was supposed to be a video that was supposed to play, but it was obviously the Ute scene from My Cousin Vinny that probably, if you've gone to law school, you have seen probably 400 times. So maybe it's an advantage that it's not on. But in order for it to be considered certification, you first have to be deemed a child. And so what is a child? So a child can be one of two things when you're relating to this particular process. One, 10 years of age or older and under 17 years of age, and that's at the time of the commission of the offense. So you got to be over 10 and under 17 to be deemed a child. Or, with relating to certification, 17 years of age or older at the commission and under the age of 18 who is alleged or found to have engaged in delinquent conduct or conduct indicating a need for supervision as a result of an act committed before becoming 17. So that's how they deem what child is. We're going to go into a couple of the other exceptions later on, but that's the definition of a child with respect to this statute. So to kind of give you a little idea, everybody kind of, well, we're going to go over it, but the process in Texas, it originally begins with the DA's decision. So one of these crimes gets in and the DA decides, how am I going to proceed? Am I going to leave it as an indeterminate petition? Am I going to do a determinate petition? Or am I going to seek certification? So in Texas, the first process is the prosecutor decides that he or she is going to do a certification. That's the first step. Okay? So they file the paperwork and they go through all the service issues, which we'll talk about in a little bit. Then there has to be a hearing in front of the judge, and the judge has to determine whether to certify or not. So under certifications, it's basically a two-pronged process. The prosecutor has to say, yes, I want to do it, and the judge has to say, yes, I'm going to allow you to do it. So that's the judicial waiver. There are two other kinds of certification processes that are used in the United States, so I wanted just to cover them briefly, just so you'll kind of get an idea about where we're at in relationship to the other parts of the country. Automatic waiver, that's basically, it's statutory. So it's the person has committed this crime, the person is of this age, then it's an automatic certification. There are still places that do that, but it's basically, it's written in there. The downside to that aspect of it is, I hear myself going in and out. Is it too loud, too soft, or is it annoying that's going in and out? Good? Okay. But it's the downside to it is it doesn't take into consideration a lot of these other issues that may be present in the case. Anybody who regularly practices in Harris County in the adult criminal system, you go through these periods of processes where you get these, demands from all the way up to the top, all the way to the bottom of, we're not going to do this anymore. And I remember when I was over there, at the time it was the DA's office will not offer deferreds for any burglary of a habitation case. So if you had any of those, you couldn't get a deferred. You had to go to the judge to get it. Okay, and so that's kind of an example that I give of what that automatic waiver is. Okay, it doesn't take into consideration, because you can think about a good burg hab versus a bad burg hab. The 19-year-old son who gets kicked out of the house because he's arguing with mom and dad, still lives at home, and then breaks open a window to go into his room to get some of his stuff back. You couldn't offer a deferred in that situation. You had to go to the judge. So the downside to automatic waivers, it doesn't take it as a case-by-case basis. The prosecutorial discretion, that's a tough word for me. My vocabulary is very small, so Jerry Michael used a bunch of big words that I had to Google, so you'll get none of that through this presentation. This is the biggest word you'll find. It's basically the prosecutor decides. So there's really no checks and balance in states that use this method. If the prosecutor wants to certify the kid is certified. So I really think Texas has kind of the best way to do this, is because you have two different people that get to look at it. So you can get two different methodologies to be able to take care of these kids. Who can be certified? So there's only two different subsets that we're going to go over. First one, obviously, is people that are a child that are currently under the age of 18. And then you have the ones where the person is over the age of 18, because there's certain ways in certification that you can actually get jurisdiction over the people in that right group. So the under 18, the charges that you can be certified for: capital murder, first-degree felonies, aggravated control substances felonies. So I had to look that one up when I was first doing certifications. It's basically your more serious drug cases, large amounts of drugs. So you think the kids that can be into that group are basically your drug mules that they're carrying kilos of coke around. Ones that basically the punishment range is not like 2 to 20 or 5 to life. There's actually a higher subset of punishment range. So those fall into that category. They have to at least be 14 years of age at the commission of those types of offenses that I just listed off, and under the age of 17 at the time of the commission of the offense. So it's 14 to 17 for the capital murder, first-degree felonies, aggravated controlled substances felonies. For your second-degree felonies, your third-degree felonies, and your state jail felonies, you have to at least be 15 years and under 17. So for the first group, 14 to 17. For the second group, 15 to 17. The category on the right, individual currently over the age of 18, your capital felonies or your murders, at least 10 years of age and 10 years of age or under 17 at the time of the commission of the offense. For your aggravated controlled substances felony, first degrees other than murder, 14 and under 17. For your second degrees, third degrees, or state jails, 15 years of age and under 17 at the time of the commission of the offense. Okay? Now, obviously, with respect to the category on the right, they've committed the offense while they are a juvenile, but now they're no longer one. Okay? When you have those particular types of certification hearings, there has to be an additional finding regarding the due diligence issues, why it couldn't be found out, but that's the other subset of it. So in order to do this, how do you get a certification? So I just said that the DA has to make a decision that they're going to certify, and then you have the filing of the certification paperwork. So the first step is, here's the 3 or the 5 statutes that basically you have to satisfy to get the certification before the judge. 54.02B, they have to be served, and the paperwork has to state that the hearing is for the purpose of considering discretionary transfer. So basically, when the child first comes into court, he or she is served with that initial paperwork on an indeterminate petition. Okay? And then when the state decides to certify, they have to file that petition, they have to serve the proper parties again, and that service has to include that this hearing is for the sole purpose of deciding whether to certify or not. 53.04, there's no reason to go into it, because if that becomes an issue, you can just look it up. But it's basically the form of service. So it's the specific language that has to be in there. It has to be the information that has to be included. It's very detailed, it's very boring, but if you were going to challenge service or you were checking service, the first thing you would do is put up your service paperwork, pull up 5304, and basically just check it off. When you're trying a case and you have the information, the charging instrument, the petition in front of you, and as the evidence is being presented, you're checking off that they're checking all the elements. It's the same thing you would do here. You just go to 53.04, make sure they've checked all the boxes off. 53.05, I don't see this one done a lot, but the hearing has to be held within 10 working days after service if the child is in detention. So that's 53.05. I think with respect to a lot of the other things that we're going to talk about later, that's why you don't hear a lot about 53.05 and it taking longer than the 10 days. 53.06, the child and the child's either parent, guardian ad litem, or custodian must be served. And then you have to attach the petition, the new petition for the certification, to that service, and you have to state the time to answer the petition. So it's, show up in court on this date at this time, here's the address. And then you have to have personal service 2 days prior to the hearing, the minimum, 2 days prior to the hearing, if in-state and location is known. If one of those is not met or that's not the case, then you get 5 days. Discretion or jurisdiction. So those two statutes, it has to go before the juvenile court. Judge, not jury. So the certification process is not a jury process. It is to the judge. So it's kind of like a court trial. Your judge is the one who's hearing the evidence. Your judge is the trier of fact. Your judge is making the determination. There is no jury involved. I actually know a colleague that I believe is trying to file something to try to change that the certification process, he's saying that the child should have a right to have a jury trial on the issue of certification. So that's a little tidbit, but it's judge, not jury. And then number 3, the district court may not remand. I was in a court when I was with the prosecutor's office in felony court that actually was an issue. There was a judge that was elected on the bench, did not believe in certifications, and was sending the certifications back and saying that I will not hear them, I don't believe in them, and was actually sending them back. So the district court can't send it back, may not remand. Oddly enough, I think most of when I crossed over and became a defense attorney, I think when my clients found out they were headed to that court, they were kind of excited, because you can imagine if you don't believe in certifications, but you have to hold on to it, what your punishment's going to be. So a little tidbit there. And I know that one of the judges that I've practiced in front of, when he was deciding whether to do certifications or not, and there was an adult co-defendant, one of his things that he wanted to know is what court is that adult co-defendant in, because the juvenile is going to get attached to that particular court. And so the judge, in making a determination on what would be in the best interest of the child or what he believed the child should go through, he actually took that into consideration, knowing some of the experience from the other judges and what they typically did on cases with certain fact patterns. That's one thing he was concerned about. Pre-hearing requirements. Everything regarding pre-hearing, and if you remember a couple slides ago, I said that the hearing had to take place within 10 days. I think this is where that's not being applied, because this stuff has to be done. If this stuff is not done, it's a bad certification hearing and it gets brought back. So 54.04D, you need to make sure that everything is done on this before you have the certification. So a full diagnostic study has to be done. Does anybody know what the definition of a full diagnostic study is? There is not one. It is not in the code. It just says you have to do a full diagnostic study, but does not tell you what that actually is. The second thing that has to be done is you have to have a social evaluation. Again, not really defined. I think that one's easier to decide what it is, but a social evaluation has to be done. Third thing, a full investigation of the child, his circumstances, and the circumstances of the offense have to be included in a report and be given to the judge. Again, full investigation, circumstances of the offense, not defined in the Texas Family Code, but it has to be done. Okay, the process. I love that. I'm sorry. It is. That's the best one. We have two separate with certifications, and they're actually spelled out completely different because there are two different processes based off of the age. So under the age of 18, 54.02A. Over the age of 18, 54.02J. I know Jerry Michael kept saying the joke, this sounds like a good test question. I tried to do this so that when you're hitting these topics, whether you're preparing for trial or a hearing or anything like that, if you come up with a particular issue, it'd be very easy to find the correct statute because it's really plainly spelled out, so you can just look it up and go straight to it. But currently under the age of 18 is governed by 54.02A. There must be a full investigation and hearing. Probable cause has to be established that the child committed the offense. The welfare of the community warrants transfer because of the seriousness of the offense or the background of the child. So in order for a judge to certify a juvenile that is currently under the age of 18, those have to be met. So you have to have a hearing, you have to have the full investigation that we talked about, and then you're going to get two prongs in the process. First, the judge has to find probable cause. So there has to be a finding. If you have an order and you're looking at it to see if it's done correctly, there has to be a finding of probable cause in the offense. And then you have that second prong, which is probably more of the majority of the argument before the bench, is that the welfare of the community warrants it because the crime was serious or the background of the child warrants it. If you're currently over the age of 18, you skip over the first part and you go straight to 54.02J. There still must be a hearing. Probable cause still has to be found, but there has to be a preponderance of the evidence that a reason beyond the control of the state is not practicable, another big word, to proceed. So they have to find that they could not proceed before the child aged out of the system. And then after there's a due diligence, you have to establish that there's due diligence, but that no probable cause before 18 and new evidence found, a person could not be found or for appellate reasons. So think about maybe a sexual assault. DNA is still in process, or it was a case that was actually, I guess, committed before DNA started actively being used in courts, and then they went back and retested, and now they found out who it was. A weapon or some other form of evidence was found that the location of which was not known prior to the child aging out. I actually know of one where a person he was under the age of 17 at the time of the commission of the offense managed to avoid prosecution into his 60s and said he was closing on to his deathbed and the guilt was too high that he couldn't hold it anymore, and he actually came in, turned himself in, and confessed the whole crime. And that was the only thing that actually tied him to the crime, so they did not, there's no way the state could have found him without having that information. So it's situations like that to where 54.02 can come in if somebody's actually technically aged out of the juvenile system. So since you're in front of the bench arguing certifications and you're making that plea to the judge about whether you're a state that, hey, he or she should be certified, or you're with the defense and you're arguing, hey, don't certify, leave it in the juvenile system, the important thing is to know where those arguments, where the case law, where this all originated. So as in everything, if you're making an argument to the bench, you'll always go to 51.01. It's the beginning of the Texas Family Code. It spells out what the purpose of the Family Code is. If you're not using any, you should at least be picking up some buzzwords if any time you're making an argument to the bench, because it's a very effective tool, because it actually states the purpose of this whole juvenile system is. And it's basically to provide for the protection of the public and the public safety, but consistent with that first prong, to promote the concept of punishment for criminal acts, but to remove, where appropriate, the taint of criminality from children committing certain unlawful acts, and to provide treatment, training, and rehabilitation that emphasizes the accountability and responsibility of both the parent and the child's conduct. Sometimes it's more the parent than the child's conduct. To provide for the care, protection, wholesome moral, mental, physical development of children, coming within its provisions. Number 5 of 51.01 to me is very powerful as a defense attorney. To achieve the foregoing purposes in a family environment whenever possible, separating the child from the child's parents only when necessary for the child's welfare or the interest of public safety, and when the child is removed from the child's family, to give the child the care that should be provided by the parents. And to provide a simple judicial procedure for which the provisions of this title are executed and enforced, to where the children are assured a fair hearing and their constitutional and other legal rights are recognized and enforced. I mean, that is actually statutorily written out in 51.01, and it's basically a fantastic closing argument. So you should tie it in. What are the magic words that are going into a certification hearing? Basically, what does the judge have to find? What is the judge looking at? What are you trying to prove? What is the state trying to prove? So the first place to look, and I didn't go for that one. The first place to look, 54.02F. It's important. It says it's not exhaustive, so it's not a complete list, but the judge must consider these things. So you have to at least address these certain things. So whether the alleged offense was against a person or property, with greater weight given to transfer given to offenses against the person. So person versus property, obviously person is more serious, so therefore more likely to be certified. Then you look at the sophistication and the maturity of the child. That's on the previous slide where it talked about the social evaluation. That's where that comes into play, because the judge has to consider that. The record and previous history of the child, so any prior involvements with the criminal courthouse. The prospects, and this one I think, as defense attorneys, we may not utilize enough in front of the bench, but the prospects of adequate protection of the public and the likelihood of the rehabilitation of the child by use of procedures, services, facilities currently available to the juvenile court. So stress it. We spend all these time looking on all these, you saw some slides on other presenters that listed all these other different avenues that we could place them into. When you're in front of the judge and you're arguing and the state's trying to seek certification, your argument is, we have so many other things that we can do. We can do this. We should consider this as a last resort. Let's put them into one of these other great programs that we have created, as opposed to just shooting them straight over to the adult system. Kent v. United States, it's one of the cases that actually looked into the certification process, so you can get a lot of buzzwords from there as well. Some of them are the same: seriousness of the alleged offense, whether the protection of the community requires waiver. That's a big one. Whether the alleged offense was committed in an aggressive, violent, premeditated, or willful manner. This one, the merit of the complaint. So basically what they're discussing is one of the factors that the judge can consider is the likelihood of success of that case being prosecuted in the adult courts. It's written there, and if you ever want to pull it up, it's Kent v. United States, and I think there's a citation later on. The problem is when the judge is considering probable cause, what comes in? Basically everything. You usually have your one cop come in, go through the whole process, read the offense report, talk about all the evidence, talk about everything that's been obtained. One thing, for example, that can come in, part of the probable cause of an offense could be a statement. Okay? But what if you find out in your investigation and your representation of the juvenile that statement's going to get tossed out? Whether the officer did something incorrectly, whether it was taken improperly, whether there's some other reason for it to be excluded, but you have determined and found out that it is most likely that this statement is not going to be being able to be used in his adult court. stress that in front of the judge, because that's one of the elements that that the judge is able to consider. What's the success of it actually being successfully prosecuted in the adult system? The Hidalgo versus State, it's a great closing argument as well. Transfer to criminal district court for adult prosecution is the single most serious act the juvenile court can perform, because once waiver of jurisdiction occurs, the child loses all protective and rehabilitative possibilities available. Basically, you can't help them anymore. You're sticking them in jail. That's straight up from that case. So if you're doing certifications and you want some tidbits on how to use a good closing argument, read this case. It's not that big, but it's very important. Also in Hidalgo, transfer was intended to be used only in exceptional cases. The philosophy was that whenever possible, children should be protected and rehabilitated rather than subjected to the harshness of criminal system, because children, all children, are worth redeeming. It actually reads like that. Children, all children are worth redeeming. That's a very powerful closing argument, puts it in the record. It gives the judge something else to consider as well. Briefly, what am I talking about next? Thank you. Cameron Moon. Read Cameron Moon. I like that. I find it funny. I don't care if y'all don't. I do. That's hilarious to me. I think that's a problem when Steve got pasta for all y'all, because everybody is so full and they're weighed down by all that heavy sauce. Two important things to take away from Cameron Moon. First of all, the trial court must set forth the basis for the order to transfer with sufficient specificity, struggled with that one too, to permit meaningful review. A lot of people don't realize I do actually have a stuttering problem, so some of these big words are very hard for me. I apologize. This is also coming straight from Cameron Moon as well. So the transfer of a juvenile offender from juvenile court to criminal court for prosecution as an adult should be regarded as the exception, not the rule. But that first part was the first big thing that Cameron Moon changed. They went back and they were determined that people were basically in the orders. It was just stating that the kids should be transferred or probable cause found. It didn't specify why. I think it should be transferred because. And they actually argued it that the order has to have that because. I know if you practice CPS law, the case that's kind of similar to this is when they would say it's in the best interest of the child, but there's no information on the record as to why. It's similar. So if you're a prosecutor, make sure that the order states out the specific reasons. I mean, you'll notice prior to Cameron Moon, the orders for certifications were very small, very thin, not a lot of paperwork. Post Cameron Moon, they're thicker now because we're basically putting in all that information. The other thing it changed, I'm not going to go into it too in depth, it changed when the appeal could be done. So now we get the appeals, we don't have to wait till the end of the case. If there's an error, it can be done immediately. So I imagine that the appellate division of both the public defender's office and the DA's office gets to work right away, right when it gets certified over and transferred over to the adult courts. I think this was a very good change. I'm very happy that it happened. And then I said at the end of the cases that I've kind of talked about, and then two others that kind of mirror these three, anytime you're doing certifications, you want to pull some buzzwords, you're doing appellate issues, you're writing the papers or anything, you should at least hit those 6. So take a look at those. How am I on time, Mr. Jordan? Okay, perfect. Determinate petitions. You have to know the past to understand the present. So basically, how did we get determinate? So determinate is actually a pretty new statute with respect to juvenile law. Before, it was either indeterminate or it was certification. So the kid either aged out when he was 18 or you made him adult. There was no in between. And then people realized what they wanted was they wanted to create an alternative to lowering the age for certifications. So the goal is, if you're doing for determinate petitions, if you wanted to do, or they wanted to be able to reach the juvenile as opposed to making them an adult. So the first thing that was proposed to the legislature was, hey, let's lower the age for certifications so we can grab in some more harsh offenses. And they said, it's probably not a good idea to be certifying kids this young. So they came up with a determinate statute, which was an alternative to actually lowering that age. Originally, the maximum sentence was set at 30 years, which was reserved for capital and first-degree felonies, and there were only 6 offenses. Okay, so it was capital murder, attempted capital murder, aggravated kidnapping, aggravated sexual assault of a child, deadly assault on law enforcement. Your maximum age of jurisdiction was 21, and you were transferred to adult prison by age 18. 1991, I'm not going to go too in depth, but 1991 basically increased. They went from 30 as the max to 40 as the max for some of those offenses. 1995, they put in 11 new offenses, so they added some more crimes. They allowed the possibility of the child, if the minimum age of stay was reached while they were in TJJD, they could be put on parole. So that was added. The maximum ranges of punishment was changed as well. 2001, you added 2 new offenses. Then you had, around 2001 was that issue that we had with TYC, which is now TJJD. So the maximum age of jurisdiction was reduced from age 21 to age 19. So that happened in 2001. There's basically a couple of the basic procedure of a determinate petition. You file the case, you have the hearing, and then what happens post-adjudication. Okay? Those are basically your 3 main topics. So the first one, how do you file a case? These 2 cases basically say the same thing. Whereas in certifications, it's a 2-prong. Basically, your state has to say we're seeking certification, and the judge has to say I agree. The state has all the power in a determinate petition. Okay? That's written in the case law. The only check and balance to the determinate petition is that you have to present the case to grand jury. So the state, when they want to do determinate petitions, they have to take the case into a grand jury. I'm assuming everybody knows what the grand jury is, but it's a group of 12 people, up to 12 people that sit in some room, and they just hear case after case after case after case over and over again. And all they have to do is basically stamp it that we agree with the determinate petition. They stamp it, there's no stopping the state at that point in time. There's up to 12 members of the grand jury. In order to have approval process for a determinate petition, you have to have 9 out of those 12 have to approve the petition. If you have less than 9, it doesn't get stamped, but if you are a prosecutor and you present a determinate petition to a group of 8 grand jurors, you're probably not going to be a prosecutor for long. I don't think it's but whatever. It has to at least have 9 people. The minimum for a stamp is 9, so it happened a couple of times where you would go in, some of the grand jurors would be either late, not coming, sick, whatever, and you would just pass the case and bring it in when there's more jurors. The approval must be sent to the juvenile court and entered into the record. So basically, you take your petition, it says determinate on the top, there's a place for the foreman of the grand jury to stamp and to sign. You present your case, as a prosecutor, you present your case to the grand jury, you hand them the petition, you leave the room because it's a secret to vote, and they either stamp it or they don't. If they stamp it, you bring it over to the juvenile courts, enter it into the clerk's file, it now becomes part of the case. The state may waive the determinate petition. Basically what that means, it was already discussed earlier when we were talking about the caps. The state can file a determinate petition and then in court, either through the plea bargaining process or whatever, can actually decide not to proceed on the determinate petition. So that's what that means. And the juvenile and the attorney can waive the grand jury presentment. So if the attorney and the child, I guess, don't want it stamped, or don't want to go through the whole process, you can waive it. Sometimes it's you're trying to get for whatever reason, the kid has made the decision, y'all have done everything, y'all want it to go forward, so you can waive that process. We talked about, remember, it started off with 6. There's your list right there. So any one of those crimes you can seek certification on. So there is a definitive list. If it's not on the list, you can't certify. If it's on the list, you can if the other elements are met. There's one restriction, the Romeo and Juliet law, that you can't refer a determinate petition if they're more than 3 years older than the victim. It does not apply to cases that are under 14. So keep in mind, because the juvenile under the age of 14 cannot consent, it doesn't do that. It has to be above the age of 14. Basically, this comes into play most of the time when, Timmy and Jenny are dating and parents walk in on them or find out what's going on, so they call the cops. The cops are like, I don't really see, they make a decision, but they have to proceed because it is a crime. So the child actually cannot be, I'm sorry, I keep saying certified. You can't be a determinate petition if that's met. So now we're going to talk about the hearing. So in a determinate petition, if there is disposition, obviously the one before this would be no disposition. But so you have a disposition, what are the two possibilities? So the judge can either put him on a determinate probation or determinate TJJD, as it's already stated before by other presenters. When you have indeterminate petitions, you're just sent to TJJD, and TJJD determines when the child is rehabilitated and when the child can be kicked out. For determinate petitions, there is a set number. So you're going to get 5 years, 10 years, 12 years. You're going to get a definitive number. The same thing with probation. They already talked about it before, but I'll just go over it one more time. There has to be 12 jurors on the jury if it's a determinate petition. 2, the juvenile has the right to have the jury determine the sentence. So it's the only provision in the family code where that's applicable. So you and the child make the determination of, do I want the jury to assess punishment or do I want the judge? If you do the request for jury sentencing, it has to be done in writing, and it has to be filed before the start of voir dire. So just make sure if you want the jury to do sentencing, it has to get done before voir dire. The juvenile court referees, associate judges, constitutional county judges are prohibited from hearing a determinate petition. The only exception to that rule is if the juvenile respondent and the attorney agree, and it is agreed in whole or in part. So if there's an agreement, for example, state offers 5 years TJJD, you and your client say, hey, I think that's fair, let's sign for it, and y'all both agree, a non-elected official can actually hear the stipulation. A lot of the smaller counties were very, very happy when that got passed. I want to buy one of my kids this shirt so bad and just have him go in for his first meeting. In order for the judge or for the jury to award probation in a determinate petition, it's kind of the same as the adult system. So the jury has to render a decision, or the judge has to render a punishment that's 10 years or less. So if you're on a case that can go up to 40 and your kid gets 20, you're not allowed to get probation. But if he gets 10 years or less, probation is an option. It has to be awarded. Okay, so the jury or the judge has to say that probation is awarded in this case. But the judge assesses the length of the probation and the conditions. So the jury doesn't get to assess all the little conditions, the programs, that part of the process. What the jury basically says is, I want to give Timmy 8 years and I want it to be probated. That's all they do. Then the judge gets to decide specifically how many years are on probation. So you always hear, 6 years probated for 4, 4 probated for 2, 4 probated for 4. The sentence is what the jury imposes, but the length of the probation is assessed by the judge, and the judge gets to add any of the conditions that they want to. It can begin at home or in the care of the chief juvenile probation officer. So it can begin in one of those two places. So now we're at the situation where there's probation, and we've decided that the probation is going to be the CJPO. The judge has to make a finding that it's in the child's best interest to be placed outside the home, that reasonable efforts were made to prevent or eliminate the need for the removal from the home, or that make it impossible for the child to return home, and the child in the child's home cannot be provided the quality of care and level of support and supervision that the child needs to meet the conditions of probation. So if all three of those are found, then the judge can have probation starting at CJPO. One funny story to this, supervision and discharge. If you are working on presentation and want to find something on that topic, do not Google discharge. You will not like the images that pop up. FYI, it's a geyser. There we go. Keep going. At the beginning of the determinate petition, I keep saying certification, determinate petition, they're supervised by the juvenile probation officer. So they first begin supervised by the juvenile probation department. The jurisdiction terminates at either age 18 if it's before 2011 or 19 if it's post 2011. The state may petition to transfer the supervision if probation is not finished. A hearing must be requested and completed before the aging out of the system. And then if discharged, the discharge date is entered and the juvenile is released on the discharge date. So basically, if the kid is placed on probation, it goes through all those processes. And this is post-transfer hearing, which is the last part of the presentation. Supervision and transfer. It's what every attorney's desk looks like in here. Actually, probably cleaner than every attorney's desk that's in here. At the transfer hearing, the judge may transfer to the supervision of the juvenile to an appropriate adult district court. It has to happen prior. The hearing and everything has to take place before the juvenile's 19th birthday. Okay, so all this process has to, if you want to go, the child has not yet been rehabilitated. They're seeking transfer to the adult court. This has to take place before the juvenile's 19th birthday. If the child is transferred and the supervision goes across the street, the petition, the grand jury approval, the judgment for the determinate sentence probation, and the transfer order are the part of the district clerk's record that get transferred. So that's it. The minimum requirements for adults are not required for transferred juveniles. That's in there because it's possible for some of the aggravated felonies or the first-degree felonies that for the adults it's 5 years to life. But in the juvenile system, a child can get younger or get sentenced to less than that. So the minimum requirements, they're not crossed over. It's the juvenile jurisdiction that applies. These two are together, but the conditions of adult court must be consistent with the juvenile court conditions. If the judge in the juvenile court determines what the conditions of probation are, puts that in the record and goes across the street, the judge across the street can't start adding anything if it's not consistent with the juvenile court. That has happened in the past. That's where a lot of the case law comes up. The exception is if somebody, remember, if you're a juvenile, you can defer sex offender registration. If a child is transferred to the adult court while on determinate probation, the decision of whether to make the child register is with the district court. So those two, though, I think there's an argument there because they're polar opposites of each other. Violations, if you are transferred from the juvenile courts to the adult courts and you screw up when you're on probation, the same juvenile restrictions and punishments are what the district court can do. So you don't have to have that 5 to life minimums and all that. Now we're at kind of the transfer hearing. We can do a couple of things here. First, the child can be transferred out of the juvenile system to the parole system. And also, you can transfer them out of the juvenile system directly to the adult system. And it depends. I mean, you can do a whole wide variety of different ways to do it. But you can go from juvenile parole to adult parole. You can go from juvenile TJJD to adult TDC, adult or juvenile probation to adult probation. So you can go different ways. But when you're sent to TDC or TJJD, excuse me, there's your minimum stay requirements. Because a lot of the transfer hearings, they all hinge on if the child has met the minimum stay requirement. So your minimum stays for each of these offenses are right there, 10, 3, 2, 1. The maximum sentences are on the other side, so that's the max that they can get. But when you're looking at transfer hearings, this is the group that you have to really pay attention to. Prior to reaching age 19, the Texas Juvenile Justice Department may elect to parole the juvenile, but you have to serve those minimum sentences first. If they're paroled prior to 19, TJJD actually has a parole division, and you're actually supervised by the juvenile parole. So if you're revoked by the juvenile parole, and you're punished by the juvenile division. If it's post 18 and you're on the adult parole system, you've been transferred, and you screw up, then the adult parole system is actually what governs what your punishment would be, not the juvenile system. Transfer to adult prison. I think this should be more like when you get out of adult prison. But anyway, transfer to adult prison. So after the juvenile turns 16, but before the juvenile turns 19. So this is a kid that's on determinate petition that you do not feel that the state does not feel that he has been rehabilitated and does not feel like we should get out of this case yet. They can afford to they can apply to transfer the case to the system. One, they have to come back to the court of continuing jurisdiction. So if you had the initial setting, you have the determinate setting in the 315th, the 315th court is going to determine whether to transfer. That court that made the determination of a determinate petition is the one that gets to hear the transfer from juvenile to the adults. The juvenile is entitled to an attorney, so the juvenile has to be represented. The attorney has to have access to all of the evidence, the files, the reports, everything has to be tendered to that attorney. I noticed I observed one in the 315th just the other day, and that's a specific question that's being asked the attorney: have you had access to the file, and have you had your proper time to prepare? And it's because it's a must. It must be recorded, so it has to be a record of it, and you have to retain the record for at least 2 years. The notice of the time and place of the hearing must be given to the guardian, the juvenile, the prosecuting attorney, the victim, and any other person who has filed a written request. So I guess one tip for prosecutors in here, if you've got that complaining witness or you have that person that's involved in the case that's really concerned about the whole process, you can instruct that person file a written request into this file that if there is a transfer hearing in the future, I have to be notified. If that person's not notified, there's a problem. I've heard people object to hearsay for some of the following things, and I don't know why, because it's in the statute that the judge can consider it. The judge can consider written reports from probation officers, professional court employees, professional consultants, or employees of the, and I left Texas Youth Commission, but TJJD, in addition to all witnesses. So the judge can review, if it's filed under the written reports from probation officer or those subset of people, the judge has to consider it. So I kind of went fast at the end because I was running out of more time. So thank you, Jerry, for not going over yours. Any questions? Thank God.
All right, our next two speakers, we've got Tiffany Dupree and John Jordan from the Harris County District Attorney's Office. Tiffany has been a prosecutor for over 13 years here in Harris County. She began her career in 2005 as a misdemeanor prosecutor. In January 2013, she was promoted to a felony chief. She's worked in a number of district courts, as well as chief in the child abuse division. Currently, for those of you who do juvenile law, you know that Tiffany is a chief prosecutor in the 313th District Court. How long have you been in there now? Year and a half. Okay, fantastic. So we get to see her all the time. So those who are down there, stop in there and say hi to Tiffany. She does a lot of training as well, as does John. We'll talk about that. They do a lot of training to attorneys, law enforcement, professionals, the medical community. One of her specialties is on prosecuting child physical and sexual abuse cases in juvenile law. She received her Bachelor's of Business Administration from the University of Houston, Ed Oliver, very nice, in May 2002, graduating summa cum laude. She's one of the smart ones. Very good. She received her Doctor of Jurisprudence from South Texas College of Law, Houston, wait a minute, graduating magna cum laude in May 2005. She's an overachiever, let me tell you. We have to deal with her in a lot of cases. She's sharp. She's very sharp. All right, John he's been a district attorney for 19 years. When I started the office, John was there. Even though I'm older than him, he was there a year before me. But we were co-workers, and John was always a good guy. We always talked LSU football. He's a very accomplished trial attorney. He's tried over 100 jury trials. He's got like 22 capital murder and murder trials, 24 sexual abuse cases. John, I hate to say this as a defense attorney, but John has put people away in prison for thousands of years. I'm not asking for a round of applause, except for the few DAs that are here in the room. You can applaud on that, right? It goes on their evaluation, John. Right, there's a booze in here, right? He's appeared on lots of national news programs, 48 Hours, Crime Watch Daily, Women Behind Bars, and Snapped. Snap sounds a little suspicious there. You may not want to put that on your phone. He is a faculty member of the National District Attorneys Association. He has taught all over the country, including Alaska, South Carolina, Florida, Louisiana. He's a frequent presenter for the TDCAA on search and seizure, cross-examination, and final argument. Within the DA's office, he's had lots of roles. He's been the chief of felony courts. He's been the chief of the child exploitation section. He's been chief of misdemeanor division, grand jury division, police intake division, and now in felony district courts. In 2017, Kim Ogg did a wonderful thing. She tapped John to become the division chief for the juvenile division. And I will tell you that I've worked with a number of the division chiefs in the juvenile division, and I like all of them. I've liked them all very much. But the innovative stuff that John has been doing, I mean, he hit the ground running. This has not been like I'm going to sit in my office and close the door and let my line prosecutors do their work. This is a working prosecutor on reform. He and Kim went to a seminar in D.C. with a lot of progressive DA's offices from all around the country, and I think it really opened up their eyes into all the things that were being done all over the country. And he's wanted to come back here and implement quite a few of these diversion programs, which he has, which were never in place before in juvenile. John and I are on a lot of committees together. We just had the pleasure of spending a week. There was a group of 7 of us from a Harris County contingency at the Reducing Racial and Ethnic Disparity Conference at Georgetown University a couple weeks ago. We had a really, really good time. I did one of my favorite things that we all learned. As amazing an attorney as John is, John had never used Uber before. And so we showed him how to do it, and he's the first guy on his very first Uber trip that the minutes started increasing from the distance the guy was to us. It started off at 2, went to 4, then 17, then 19, and I think the guy charged him because John wasn't there because we had to call another Uber. So John started off with a 1 rating on his first Uber ride, so the rest of us had to call the Uber rides, and we shuffled around D.C. And lastly, I'll say one thing about John is, a trial. And again, I'm not proud of this because I'm a defense attorney, but you all remember a famous trial since I boasted about Rick, the John Hernandez trial, which was the famous Denny's case, the murder trial. And John, the DA's office tried that case, and it was a hung jury not only for murder, but for manslaughter all the way down to neg ham. The jury was like 11-1 for not guilty. One juror held out, 11-1 not guilty. They decided to retry that case. They brought in the A-team, brought in John to try it along with Sarah, and they not only got a guilty on the murder, but got 25 years in prison for John Hernandez's killer. So he's a badass, and that's why I like him to be a chief and not in the court. So, all right, with that ado, they're going to both have microphones. They're going to do this together, John and Tiffany.
Okay, so you want to go fishing, you want to play outside in the beautiful weather, but we're going to talk about law enforcement, woo, search and seizure, sounds fun, and defendant statements.
I love how Steve introduces me to a room full of defense lawyers saying I sent someone to prison for 25 years. It's like, thank you for letting me lose the room immediately. It really is a pleasure to be here, guys. I've spent 18 years in the adult system. I know my people handle the courts, and I've been working behind the scenes trying to reform what we're seeing, trying to reduce the number of clients you get by reducing the charges. We'll talk about that in a minute. But I've never been around a group of people who sincerely care about their clients like you do. Some of those people like Spence in the adult system, you really don't care about your clients like these folks do. And it really is amazing to see the dedication that y'all have, and it's a pleasure to be over here. We want to start with how we take cases. For years and years, for about 15 years, the intake procedure went through the adult intake system. For 24 hours, 7 days a week, law enforcement would call adult intake and run a juvenile's fact patterns by them. Once we took, about a year ago, we realized that was probably a bad way to do it, because I can tell you what would happen. An adult DA would kind of start listening, and then they would hear that it was a juvenile, and then they kind of quit listening, and they'd say, go ahead and file it, because it was like, no big deal, it's just going to juvenile court. So what we did is a year ago, we changed that from at least 8 to 5, Monday through Friday. If a youth is stopped, they have to call and speak to one of the juvenile DAs. And we're always there if somebody is in the office. Many times it's me if everybody's in court. And we think, and hopefully we're educating them as they call in, and changing the culture of law enforcement in Harris County. It's just going to take a while. Now, if in the nighttime, as well as on weekends, they do have to call adult DA intake. However, we still, as we always have, we review the JOTs the next day. If it's over the weekend, we review them on Monday morning. So there still is a chance for us to reject the charges, even though an adult DA has done it. So before a petition is filed, a juvenile DA will be reviewing the charges. And also I want to tell you all, because a lot of folks don't realize, we did change the procedures or the criteria for a DA to accept a juvenile case, okay? And we did this a few months ago, and it will take a while to change the culture of law enforcement because, as you know, HPD has 5,000 officers. Sheriff's Department, there's thousands of officers that we're trying to educate one call at a time. But in the adult system, as y'all well know, all a DA has to listen for is probable cause. Go ahead and file the case, right? Well, what we have created is 3 more steps in order to file on a juvenile. The second step, after, obviously you have to have probable cause, but after probable cause, we ask them to, let's talk about the nature of the conduct. And what we mean by that is there's certain conduct, as y'all can educate us on, that it's more youthful behavior. that if an adult would do the same thing, we would charge them all day long. But because it's someone who's young, with their hormones and their immaturity in their brain, they do it. Society says, maybe we shouldn't charge this person. The prime example I use is, say, a Class B terroristic threat. If a husband's telling his wife, I'm going to kick your ass, I'm going to kill you, whatever, we'll charge that all day long. If we have 2 kids who are 15 years old in a school doing that same thing for years and years and years, we've charged them. We're trying not to do that now. Does that make sense? Or, well, there you go. I got my 25 years back. And the idea is all the assaults that occur in school and all of those types of things. And this gives us cover, because Kim Ogg approved this, because what it is when officers complain, why aren't you following it? The elements are met. I can say, we have a procedure. We're looking at the nature of the conduct. Now, it's a case-by-case basis. I need more experienced people in my division to affect this, but I think we're going to change the way things are done in Harris County. Now, then we go one step further. We also look at individual factors, and we call it, it's the things such as we can actually look at the age of the youth. Are they 10 or 11? Are they 12 years old? We can consider that. We can look at their disability, okay? And these are kind of learning from when we did all those terroristic threats in the schools, where we charged more than anybody in Texas. It was my fault. I was the one that was doing it, but then I paused and said, let's analyze it. And some disabilities, Texas people were busting my balls over it, and did I just say bust balls? I'm sorry, I'm on video, that's all right. But it caused me to pause and reanalyze and look at the analytics, and it was bad, right? And so we can look at, do they have a disability? Are they ADHD? Are they autistic? Do they have things that would influence them in that youthful behavior where we shouldn't charge them? So we can look at those factors as well. Then lastly, even if all that exists, is there a diversion program that's appropriate? If there's a diversion program appropriate, we want to funnel them to the diversion programs. And we're trying to expand them. Y'all heard about some of them through Jamie this morning. We have that family violence. We have a sexual assault. We expanded the P program to include violent misdemeanors as well as felonies. And hopefully, coming to a school near you, we're going to be creating a school diversion program, hopefully in every school in Harris County over the next year. So we listen to you. Now, unfortunately, it's going to reduce y'all's caseloads and y'all's money, but I think it's going to help our county. So, all right. And then lastly, after y'all applauded that, we do have exceptions that this 4-step process does not include murders, capital murders, and aggravated robberies. Okay? There you can go boo, hiss, but, we have to, So there we go.
As Jamie talked about earlier, we do have the sex assault intake that takes place on Friday mornings. A panel of us meet with officers every Friday morning. Previously, in years past, our juvenile division operated differently than any other division in our office. No other division in our office does officer drop off a packet of information at the DA's office, poof, he vanishes, goes back to his desk. Whenever some prosecutor has some spare moment, oh wait, that's never. Do we review the file, then track down officer and ask him questions? It doesn't work that way in any other division, but for some reason in juvenile, that's what happened. And so as you can imagine, cases would get old sitting on desks. There wasn't a lot of accountability from the officer because he would just kind of drop and run. And then it would take time for us to follow back up with them to say, hey, can you go do a few more things? And then we got to wait till they get back to us. And as you can imagine, when people get moved around, that process really delays. Now officers meet with us. They actually meet with a team of chief prosecutors, so it can be 2 or 3 of us on any given Friday morning. When we meet with the officer, we make the decision right then. Does additional investigation need to be done? Then we can give them those instructions, and they can come back and visit us another Friday to re-review their case. Does a petition need to be filed? And then we can work with them on how to start that process. Some of them have never filed on a juvenile, and they don't know what to do. Or we can decline to file the case at that time. By doing this one-on-one interaction with the officers, we're able to really evaluate the case better and determine what is the most appropriate conduct, or what is the most appropriate action? Should they have a petition, or do we do the BASE program? I want to encourage you that if you ever hear about the BASE program, this is not a bad case just gets, and when I mean bad, I mean a case we can't make. We don't just say, oh, well, we can't really make this case, so we're going to send them to the BASE program. We just flat out decline those cases. If the case is not something that should be filed, we do not refer it to the BASE program. The BASE program is a case that we would file, but we have determined that it's in the best interest of the case and the child that they be referred to the BASE program for counseling and therapy. So I do want to reassure you that we're serious when we say if you don't go to counseling, you would be filed on. It is a viable case. And we were very proud that last year, in 9 months of starting it last year, we cleared over 177 cases. So it really cleared out a backlog. We asked the officers, if the charge is accepted on a Friday, to please apprehend the youth within 1 week so that they can benefit from the services that the Juvenile Probation Department has, as opposed to the case stalling out when the officer doesn't go arrest them and is waiting and waiting.
And two things on that. What we found is that under the old system, charges were authorized. They were told to pick up the kid. They never did. And we had literally filing cabinets of cases where the kids aged out, and we just had to get, obviously rid of the cases. This way, at least, if we authorize charges, they're going to be apprehended. We can get them the help that they need. And make no mistake of it, when we say we cleared 177 cases, probably about 60 or 70% of them were declined. This wasn't, filing a whole bunch of cases. We even did the analytics that if, say, the kid was now, old 16 or 17, and because the officers waited forever, we did the analysis. Would this be a determinate case from the beginning? We're not going to penalize the kid, and if it isn't, then we wouldn't file on him, because what's the point of filing if you only have 9 months to complete the case, right? So a lot of these cases, and then I think it's helped the officers understand to try and put these cases on the front burner, because generally what was happening, they'd rather go after uncle or grandpa thinking, well, it's just a juvenile, and what we've now educated them, well, if you get them when they're 14, we can actually change their behavior and get them to therapy, and they'll never recidivate again. So we've really put it on the front burner to really change the culture of the way that they are dealing with these sexual assault cases.
So officers, when dealing with youth, you oftentimes are doing a warrantless arrest. And the code actually specifically provides for instances of warrantless arrests of youth. A child may be taken into custody by order of the juvenile court. That's going to be what we oftentimes call an OIC, or an order of immediate custody. That's when maybe, for example, they're on pat release, maybe they are on an ankle monitor on an aggravated robbery and they're not following their conditions, or they cut off their ankle monitor. Then the court can issue an OIC, or an order of immediate custody, to have them arrested. Also, if there's probable cause to believe the child has engaged in delinquent conduct, that's going to be things under our penal code that we've been talking about all morning. That's most of the cases. There is probable cause to believe child is in need of supervision. That's going to be our runaway status, maybe the prostitution cases, what everybody's called a CHINS case. If there's probable cause to believe they have violated a condition of probation, then there can be a warrantless arrest. There's no need for a warrant on that. And also pursuant to a directive to apprehend. And a directive to apprehend comes from the court and is signed.
And for those that just do adult stuff and don't do juvenile stuff, as Tiffany just said, obviously if we just have probable cause, we can go ahead and arrest them. We don't need a warrant. Then, even though it's titled unnecessary delay, once a law enforcement officer lays their hands on a kid, the law says there's only certain places you can bring them, right? And so those places are, you can release them to the parent or the guardian. You can bring them to a detention facility. You can bring them to a medical facility if they're injured or hurt. A juvenile processing office, we'll talk about in a little bit, as well as a diversion program. Now, this isn't the P program. This would be more like the LEAD program. You all know we're doing a LEAD law enforcement diversion program in Attucks Middle School. Say a kid within that school commits a crime, a petition's never filed, a JOD is never filed, we've actually given them authorization, if it happens within that middle school, to go ahead and place them in diversion. This statute allows us to do that because they lay their hands on the kid and we don't have to do anything else. And then obviously you can always go back to school. So that's the parameters.
And so this has to be done without unnecessary delay. There's not a specific definition of what that is, but we can look to the courts for some guidance. The court has said no good to go to the juvenile processing officer and then at the office and then at the suggestion of the youth to take them to locate stolen property. So basically the code is saying, or the case law is saying, that you have to do one of those things John specifically laid out. You can't then, the juvenile says, well, I want to take you to where my stolen property is. They cannot do that. That would be unnecessary delay. Also, going to a homicide office for a statement instead of the juvenile processing office. Some homicide offices are designated juvenile processing offices, but if they're not, they have to go there. They don't get to go to a homicide office. It is okay, though, for there to be delay in some situations. Having a youth in a police car for 50 minutes while attending to a victim and talking to witnesses at the scene, that's been held to be okay. That 50-minute delay was allowed to finish processing the scene and making sure the victim did receive proper treatment. Holding a youth at a scene to identify them. So maybe, for example, in an aggravated robbery, if they need to have them identified before they arrest them and take them to detention, that has been approved for them to be held for that amount of time. Holding a youth at a scene briefly while the crime scene is being secured, that has also been held not to be an unnecessary delay. What's interesting when you're dealing with juveniles is the APHIS process is quite a bit different than the adult system. In the adult system, if you have somebody who's arrested for unauthorized use of a motor vehicle, they're fingerprinted, booked in, and they're in the Harris County Jail, if officers continue their investigation and then file capital murder charges on them, they don't go check them back out of the Harris County Jail and re-fingerprint them and all of that. They can just add a second in-custody charge. In the juvenile system, every referral has to be re-APHISed. They have to be reprinted and they're rephotographed. And so if you ever by any chance have that scenario where you learn that your juvenile was checked out and additional charges were filed, that is the proper protocol. They have to be APHISed on every single referral, not just add an additional charge. Also, when an officer arrests somebody or detains a juvenile after they have started the process to fingerprint them and photograph them, they call the Harris County Juvenile Probation Department, and it's after a conversation with them that it's determined whether or not the juvenile remains detained or he or she can be released to their parent or guardian. Officers at this time also are supposed to call the parents. It is required that the officer make reasonable efforts to give prompt notice of the arrest to a parent or guardian. So, of course, what's reasonable efforts and what's prompt notice? That's, of course, going to be what's always the question. There isn't exact definitions of what is reasonable notice. Reasonable efforts and prompt notice. But what I can tell you, it's pretty broad. The officers just need to be making efforts to get in touch with the parent or guardian of the child. The courts have held that if, for example, they call to the house and an older brother answers the phone and says, well, I don't know where mom and dad is, the court has said it's better for officer to go ahead and tell older brother, even though they're not parent, that the juvenile has been arrested and detained than to just say, oh, well, I'm just going to keep trying to call the mom. The court has said it's better to give some notice because maybe brother can track down mom quicker than officer. And so they are required to make those efforts to give notice to the parents when a juvenile has been detained.
Okay, now we're going to switch gears and talk a little bit about statements, whether it be non-custodial or custodial. And as already been previously discussed, the code defines what a child is. It's anybody's conduct that is under 17, but a child also includes someone who is 17 before they turn 18 if the conduct was before they reach the age of 17. But for the purposes of the statement, the key is this. It's at the time of the statement, how old are they? If they are obviously 16 to 10, then juvenile law is going to apply. You treat them like a juvenile for the purpose of the statement. If they are 17 and not 18 yet, at the time of the statement, you treat them like a juvenile. But once the kid turns 18, even if it's for juvenile conduct that happened, then now they're an adult and the actual Code of Criminal Procedure applies and you don't have to do what we're about to discuss.
Regardless of whether your statement is in custody or not in custody, it always has to be voluntary. You cannot give a coerced statement just because you're not in custody. So all statements, regardless of in custody or not, must be voluntary. The child may not be coerced, threatened, or promised anything in exchange for their statement. When determining voluntariness, the court is going to look to a totality of the circumstances. None of these things are firm factor. They're all factors. None of them standing alone will be what the court looks at. They're going to look to whether or not the length of time the child was left alone with the police. How long was the child with the police? They're going to look to see, was the child given their Miranda warnings in the right language? I mean, if you give a child their English warnings and they speak Spanish, that's not going to go very well. So they're going to look to see what was the age of the child, what was their intelligence, and what was the maturity of the child at the time of the statement. And looking at all of those things, that will help the court determine whether or not it was a voluntary statement. When looking at non-custodial interrogation, your first thing that you're going to want to do is determine, is your kid in custody? And the court looks at some of these things to decide, is the kid in custody? Were they arrested? Were they placed in handcuffs? Obviously, if they were placed in handcuffs, it is a possibility that they're going to be viewed as in custody. Maybe not, but that is going to be an indicator. Was the child told they are free to leave? You can go home or you can go back to class during our discussion. Were they taken to the jail or the juvenile processing office in the course of their statement? Any of these factors are going to help sway the court one way or another as to whether or not the child is in custody. Were they fingerprinted and AFIS'd? If they're not fingerprinted and AFIS'd, if they're not taken to the jail to give their statement, it's more likely it's non-custodial. And finally, were they allowed to go home after the statement is taken? You'll see a lot of times that the officer, even if they have probable cause, even if the juvenile it confesses to capital murder, we will still advise the officers to take the juvenile home. They may be down the street watching to make sure they don't run away, but our advice is always going to be, if the statement is supposed to be non-custodial, let the kid go home at least for some period of time.
And as you all know, you don't see that in the adult world. I mean, if we arrest somebody in the adult world for aggravated robbery, murder, or capital murder, and they confess to said crime, they're going to head, because the law will allow us to arrest them at that moment for that confession without getting a warrant. We think that we technically could take them into custody, but we want to be careful. So we always advise officers, you said you're going to let them go, no matter what they tell you, you go home. I think we had one in the last 2 years where it was a gang-related crime. They truly let her go home, let the person go home, but within a couple hours, we were truly worried about retaliation of who she also said she did it with, who was getting off work. So then we went ahead and authorized an arrest a couple hours later. But that's about as close as we've come, but we still let her go home, even though it was a brutal murder. The quintessential case on this is the Martinez case. And it was a horrible capital murder in the 2000s. These immigrants, man and wife, opened up a dollar store, and they had these two youth that came in several times that morning. One of the youth, who's 15, asked where his wife was. He said, she's laying there on the sofa. Next thing you know, he is shot in the mouth. As he's falling to the ground, he overhears the youth say, shoot her, and then he passes out as he's watching them go through the cash register. He then crawls out after calling 911, and when the police arrive, he is life-flighted to the hospital. Meanwhile, his wife had been killed behind the cash register, shot execution style, laying on the ground. They were able to clearly develop probable cause. The kid who did not shoot had confessed to his girlfriend. She then led him to the murder weapon, which we wrapped the bullets back to the capital murder. Showed the widow, the husband in the hospital, photo spreads of both youth. So clearly we had developed probable cause. But at that point, what the officers did is ask the youth, hey, do you mind coming down to the police station? You can either come in a marked car or unmarked car, or you can come yourself. Ask the mom to come down to the police station as well. Came down to the police station. They told him, no matter what you say, you're going to get to go home. They purposely were in an interview room. They purposely didn't have their guns showing. and the youth ended up confessing to capital murder. And sure enough, when he walked out of the room, he tells his mom, this is what I told him. And then mom says, okay, you're grounded. That wasn't enough. But literally, that's what the case says. Is she said, you're grounded. They let him go home, and then they subsequently arrested him. And so it was a horrible crime, but the officers did everything right. And they weren't playing a loosey football. They truly did, and there was no thing in his mind that he ever really thought he was going to be arrested.
And if the juvenile is not in custody, then the strict requirements of the Family Code of 51.095 do not apply. And we're going to tell you what those strict requirements are. But that is the benefit for the state of doing non-custodial. The paramount standard that you're going to be looking for comes from a case from the United States Supreme Court out of North Carolina, and it sets forth the reasonable juvenile standard. And in that case, it was a 13-year-old who was in the 7th grade, and he was suspected of committing 2 burglaries of a habitation. And they had seen him on video surveillance at the school walking around with some property that had been stolen in the burglary of a habitation. And so officers are called to the school, and administrators and officer pull kid out of school class, take him to a conference room, shut the door. They talk to him for at least 30 minutes. No Miranda warnings are given at this time because he's at school and in a conference room. He does end up confessing to the burglary. And what the court was looking at, what the United States Supreme Court was looking at was, do you look to the age of the child? Is the age of the child a factor in determining whether or not they are in custody and whether or not the juvenile perceives that they're in custody? And the United States Supreme Court said in that case out of North Carolina that yes, we're going to look to see, would a reasonable child of the same age, in the same objective circumstance, believe their freedom of movement was significantly restricted. And they said that that is going to be the overriding view of looking at whether or not someone is in custody for purposes of non-custodial interrogation. And for these statements, they can be written or oral, and they do not have to be recorded. So then that's going to bring us to our next question of, is the child in custody?
And basically, we do have a reasonable juvenile standard, and you can see what has been delineated here. The quintessential case here is the SAR case, and in that case, it was a child that was accused of capital murder. Now, what they did there is 4 officers went into the home, pulled the youth out of the home, put the youth in handcuffs in the back of the patrol car, brought to the police station, fingerprinted and photographed, but told you're not in custody. And the court says no, that's everything about those facts would tell a youth that they truly are in custody.
And when you're looking at are they in custody, the court is looking at these 4 factors. Has probable cause already been developed to arrest the juvenile? What is the subjective intent of the police? Is the juvenile the focus of the investigation? And what is the subjective belief of the child? And they're looking at all of these factors all at the same time. No one factor is more significant than the other. And in fact, you can be the focus of the investigation and still not be in custody.
Is Martina still here? Are you back? Okay. Martina and I had the privilege of trying a case a couple years ago now, Martina, probably. And it had a 17-year-old and a 16-year-old, so it had all kinds of great legal arguments. And in the 17, it was a satanic murder case that happened down in Clear Lake that y'all are probably familiar with, where 17 for certified 16-year-old brutally raped and tortured a 15-year-old girl down in Clear Lake in a vacant apartment. And the 17-year-old, they went into the home, AR-15s, he was sleeping, pull him out, handcuff him, put him in the back of the patrol car, and then say, do you want to voluntarily come downtown with us? And they did, and then they came downtown, and they got a great detailed confession, which was of no use to us because clearly he was in custody and his Miranda warnings were not written. On the 16-year-old, a different set of facts, although he clearly was given his magistrate's warnings properly. It centered on the voluntariness, on how many officers were in the room. Let me throw you a lifeline, and we survived because Jessica Caird is amazing. But it was an exercise of all kinds of legal challenges.
There's actually a case out of the United States Supreme Court on this issue. It's right out of Harris County. It's the Robert Kopp murder case, and it's near and dear to my heart because it happened at my high school while I was in high school. Robert Kopp was a fellow friend of mine in high school. I didn't really know him, but I did go to high school with him. And while we were in high school, he and a friend got together, and the friends, so the girl's name was Destiny, and Destiny actually went to high school with me also. I believe she was a freshman when it happened. The brother of Destiny and Destiny got in a fight, and there was some idea they were half siblings, that maybe there was a sexual relationship going on there. But the Robert Kopp and her brother stab her and bury her in a sewer in her back area of her neighborhood in Friendswood. And so for 2 weeks, we were all looking for Destiny, and Robert Kopp, who was 17 at the time, he had just turned 17, was out on the news saying, "We're looking for Destiny, we're going door to door." We all had our yellow ribbons searching for Destiny for 2 weeks when they had put her in the sewer in Heritage Park. And so ultimately what happened was her brother failed 3 polygraphs and then confessed that he and Robert Kopp had stabbed her and buried her in the sewer. Well, obviously that case was fine on brother, but what happened was because he had failed 3 polygraphs and they had no corroboration, they didn't have probable cause to go arrest Robert Kopp because he wasn't a credible and reliable witness and no corroboration. Somehow they still got a pocket warrant, and they went and pulled Robert Kopp out of his bed at 3 a.m. with multiple officers. It was January, and he went fully clothed in boxers, flip-flops, and a T-shirt down to the jail. When he got down there, they said, "Hey, we need to talk." He says, "Okay." They handcuff him. He does get Mirandized and partially confesses that he stabbed her and helped get rid of her body. So at trial, the state argued it was non-custodial because he said okay when they said, "You're going to come talk to us." And the trial court said that was fine. It was non-custodial, but the United States Supreme Court said no. Shocker, they said going with more than 3 police officers handcuffed in your drawers and flip-flops and a T-shirt was in custody. So, and also having the Miranda rights given to him did not separate the illegal arrest because they didn't even have probable cause to go get him. So his confession was ultimately thrown out. He had gotten 55 years at trial, and I actually learned yesterday he pled to 24, so he gets out in like 2 years, which that kind of makes me sad. But nonetheless, the statement was custodial, and giving him Miranda did not separate the fact that that was not a proper separation from the arrest, from the illegal arrest.
Moving to the custodial statements.
So on these next slides, all of these things are required in the code for custodial statements, and it's very, very strict, and we have to follow it exactly.
So the first thing is the magistrate's warnings. As you all well know, if they're in custody, a magistrate has to read them their warnings. And it can be any magistrate, can be a JP, a city judge. And often is the case, as y'all know, when we have the smaller jurisdictions, sometimes they'll have the judges come in the room, reading the rights in the video room, then the officers continue to give them their rights. Historically here in Harris County, as far as HPD and Harris County Sheriff's Department, they would then bring the youth right to downtown to the CJC. They go into the chambers of the judge would read them their rights, and then they would bring them back to homicide, a juvenile processing office, and get their statements. One of the things is that they do have to be alone in the room. And that was always done. They would go into chambers. Now, the only way that a bailiff or an officer should be in the room is if the judge themselves says, Judge, if you say, I'm afraid, based on something, I would like a bailiff to be present, then the bailiff can be in the room, and I guess you just take measures so that the child doesn't feel intimidated and things of that nature. But generally speaking, in the past, and y'all could probably tell me if y'all know differently, it seems to me that most of the judges feel comfortable talking to the youth alone in the room, and perhaps there's a mechanism in place if they feel for their safety. The devices, it has to be recorded on the same device as the statement, okay? Now, as y'all know, what has always happened, especially with our homicides for HPD and Sheriff's Department, is they would bring them to CJC, they go into chambers, the officers would leave their audio recording device going, right? You would hear those warnings done, so we're good, and then they would bring the youth where? The Sheriff's Department homicide or HPD homicide, and have this beautiful video statement of the youth. Is that video statement admissible? Not at all, in any purpose. So hopefully, for the state's purpose, we kept that audio device going in the video room, and so that always has been problematic. It obviously has to be on the same device, and I guess it's kind of, whether it's the same, you can pause it. We always recommend that our officers keep it running from the warnings all the way to the video room. One of the things as a juvenile processing office, as you all well know, the juvenile board has to approve it. And there are certain things that you can do from that juvenile processing office. One, release to the parent. That is also where you can fingerprint and get them the booking photo, complete reports, and also give the warnings. I want to come back to that because in the last juvenile board meeting with the Joint Processing Center right down the block that y'all are familiar with, nobody had ever really thought about processing juveniles in that facility. I didn't think about it. Nobody thought about it. And then all of a sudden, one of the sheriff's deputies says, what do we do with our juveniles? And as you know, part of the juvenile processing office, once you have a kid in custody, you can't bring him in front of other inmates. And so at that Joint Processing Center, youth were going to encounter other inmates because they all would go to the back sally port. We have now come in with a procedure, and this week the Juvenile Board has designated a juvenile processing office on the second floor of the building. What we're going to do is officers are going to bring them through the front, and they're not going to have any access to the adult detainees because they all come in the back. We're going to bring them through the elevator so they won't have any kind of encounter with an adult suspect. They will go up to that second floor, and there's a juvenile processing office of which the magistrates then will come from their chambers, because their chambers in the new Joint Processing Center were all around all the adult offenders. So that old system of bringing them to chambers was not going to work. So these 24-hour magistrates will be able to go into that juvenile processing office and give them their warnings. Right now it's set up with just the audio recordings like we've always done, but we're in negotiation to get video equipment that we can access so that the warnings, and y'all are going to love this, right? The warnings as well as the statements will all be on the same recording device so that you can see the coercion or lack thereof. I just can't believe I said coercion. The lack thereof of coercion, hopefully, and also see the mannerisms of the kid and all of that. So that second step is in the works, and that should happen hopefully within the next month, but we do have the designated juvenile processing office as of this week for the Joint Processing Center.
It's also required that all of this be done in 6 hours. There is a 6-hour rule that the youth may not be detained in a juvenile processing office for more than 6 hours. And so that is very, very important that they move quickly. With regards to written statements that are custodial, you don't see these very often, and here's why you don't see them very often. You still have to go before the magistrate to receive their warnings. The written statement must contain the warnings provided on it. And then here's the real kicker. After the statement is made, the youth goes back to the magistrate a second time to have the magistrate verify and sign the statement in the presence of the magistrate without an officer or a prosecutor present. And then the magistrate has to make findings and certify that the statement, the youth understood their rights, it was voluntary, and the youth waived their rights and signed. I will tell you that the magistrate can require on a recorded statement that they bring the juvenile back to do all of these things. It's just very rare. At this time, we don't really see that often. We are just about out of time, so we're going to finish up talking about searches with regards to police searches and administrative searches.
As you all know, just like in the adult system, juvenile, the standard is probable cause. Officers have to have probable cause to search. Now, when it comes to schools, it's a little bit different. When it comes to schools, if it is a campus officer, someone who's there all the time through the ISD Police Department, the standard is actually reasonable suspicion. The rationale is you're sending your kids to a school. The school is should be a safe environment for that school. You're taking custody of that school. So in the same way that the school officials, if it's not part of administrative search, needs reasonable suspicion, so do the officers. Now that's different if you have an outside officer like HPD come in from the outside and not part of a school police or campus officer. They're going to have to revert back to probable cause, okay? And speaking of that, let me get on my soapbox again. When I was talking about the things that we're trying to change, we are truly trying to change the referrals that originate from the schools. Y'all probably realize this in your practice, that 40% of all arrests of juveniles come from the schools. That's ridiculous. I mean, the places that kids should feel safe is in their own schools and in their own homes. And so we're trying to change the culture of the school police to let them know that we're pushing it back to the school discipline. We're talking about we should see very few assaults. You should see very few Class B terroristic threats. You should even see less criminal mischiefs and things of that nature that they can handle. You should see less thefts, that if they get the iPhone back by the 7th period, things of that nature. So again, it takes us a while to change the culture, but we're truly working on that endeavor. Yes, ma'am. There you go. Now, I know you. Your baby ain't doing anything wrong. No, and obviously y'all all know this. There's a difference between the school officials doing it and then once law enforcement's doing it. And I think back to whether they're in custody or not, and it is a concern that if the officer, they're trapped in school, officer brings them in. That's why I think the words the officer uses is very important. No matter what you tell me, you're going to go back to class, things of that nature, depending on what the investigation is. Because, we actually teach our officers, and hear me out on this, you should never be in a situation where you're reading their rights, because we try and convince the officers, look, if you have a kid in custody, you can't read them their rights. You have to have a magistrate reading them, because a lot of times y'all have probably seen they read them their rights just in abundance of caution, then it looks like they're in custody. And I know it's a gray line there. Clearly, if the administration's doing it as part of their investigation, we come in after that, no problem. Once officers on campus are involved, it could potentially be a problem. But that's why the communication of the officer is so important to say, no matter what you say, you're free to, give me a statement, you're going to go back to class, and truly make them go back to class.
And the search, I'm just going to skip to the end because here's basically the bottom line. And the search has to be reasonably related to the objective. So, for example, in a case out of Waco, kids were smoking pot in the parking lot. Principal's notified, and she sees the respondent. He's like messing with his pocket, and she's like, "Hey, what's in your pocket?" And he's like, "I'm not telling you," or "I'm not nothing." And so she brings down an officer who is assigned to their campus, and that officer pats him down. He says, "I knew that was marijuana, and I immediately went in the pocket." That was completely okay. He had reasonable grounds that the search would turn up evidence that he had violated the law or a school rule. It can even be that because it's policy driven when dealing with schools. Contrast that with a student is just skipping class. The court said no good to go search his locker, and his car, just because he was skipping class. So you just have to look to see what was the purpose and what are they looking for, and just to make sure that it stays within a reasonable parameter to be justified. And so that pretty much wraps up what our topic was covering. Does anybody have any questions? Yes, sir.
At the beginning, you said now we have juvenile DAs for intake calls. So we say it's from Monday to Friday, regular working hours. Why not like regular for 7 days?
Good question. First of all, the office employs people. I'm sorry. The question was, why do we only do juvenile calls in our division from 8 to 5, Monday through Friday? Our office is unique jurisdiction where we have a 24-hour intake 7 days a week. We don't have, I can't ask my juvenile DAs to work 5 to midnight and midnight to 8. I just
Stop that, Mark Castillo.
Unless you want to go to Commissioner's Court and get us a lot more money for that, sure. But this is the deal. I think it is important to know this. We have trained the DA intake staff of our new procedures. We've tried to get the message out that this is what you should be doing and you should be pausing. We say, once you hear probable cause, pause, because you are going to affect a kid's life for the rest of their life, as opposed to the adults you deal with. But keep in mind, we will be reviewing every single jot before anything is filed, and we're going to be doing this step process. So yes, it would be bad. The worst case scenario, a kid that shouldn't be arrested is maybe in detention for 48 hours, but we still have a stopgate that before the case is filed. Great question. Yes.
Curious to get your take on searches with regard to anonymous tips.
You know, all right, so if it's a police officer in the school, remember the standard is going to be reasonable suspicion. So through anonymous, obviously with probable cause you may not get there because you have to have a credible source. I would think anonymous tips may get us there for reasonable suspicion. Would you agree with that, Jessica?
She's saying it would, if you had anything else, you would get there. It's a factor that you're considering with everything.
Potentially could.
Well, yeah, so if they get an anonymous tip that there's going to be a massive shooting at a school, can they set up a checkpoint at the front door and check every single kid's bag? Yes, they can. They can't say only one race or only one gender, but they can check every single person on that. Yes, ma'am.
What does the court say about voluntariness on the statement, not regarding custody or not in custody, but just regarding age? Like a 13-year-old, I mean, are they ever going to feel like they can't answer an adult's question?
Let's hope they would never say never, but the age is a factor. I mean, the courts do say 10 or 11, 12, you know, I guess once you get to the 13, 14, 15, 16, it's going to be different, but that is going to be one of the factors that they're going to consider on voluntariness.
So they had struck down statements regardless of custody, in custody, out of custody, just based on age?
I don't believe that. I wouldn't say that strong. Jessica, you want to, do you know?
I just want to know what's happening.
I mean,
Voluntariness, it is a factor that they weigh in voluntariness as to the age of the child. It's one of those things they weigh as to whether or not the kid really understood what they were doing.
Right.
It's a judicial factor that the court looks to, but it's not the only deciding factor. You have so many other moving parts at play where they're weighing the circumstances, who this adult was there a gun visible, all of those other factors are things the court can look at as well to say if this appears to be voluntary.
but I think to answer your question, I think what you're asking is, has the court said, okay, because you're 11 or 12, you're incapable of giving an involuntary statement? I don't think so.
Said that because you can be competent to testify as a witness as long as you know the difference between a treatment and life. So they look at whether or not you're competent to make decisions.
So I think if that's your question, I think the answer is no. Age alone is not going to just say you can't give a statement voluntarily. Okay. Thank you so much. Y'all have a great
Thank y'all.
weekend.
Appreciate it. The next speaker is Dustin Rynders. He's the supervising attorney of the educational team of Disabilities Rights Texas, a nonprofit law firm and member of the federally authorized protection advocacy. Hey now, come on now. We're starting up again. There might be a legislative exception for talking during the break. I'm not sure. Before I came to Juvenile, I didn't even know what Texas Disabilities was. I mean, and they're just an amazing nonprofit group. And Dustin and I are involved in several committees, and you'll see his passion for this work. When I mentioned the school threat cases, I was on the news telling people not to threaten people. Then he was the next segment saying John Jordan's evil. He shouldn't be charging so many kids. But, from his organization, I do know back to the schools that 50% of all school filings have kids with some type of disability. And so now that we're partners and we're working together, we really are going to change the face of Harris County. And he's going to talk more about his organization and how they can be a help to you, because they really are your partners. But he works as an adjunct professor of special education law at the University of Houston. He's a sought-out presenter on national conferences and obviously here locally, so we're lucky to have him. And I'd like to introduce to you Dustin Rynders.
Thank you very much. It was wonderful to hear that you've been going around to area school districts and telling them not to send over the silly fighting cases anymore. And we've been hearing some positive things already coming out of that. So I appreciate your efforts, and I'm really glad to be here. For any of you who aren't familiar with who Disability Rights Texas are, we're federally funded. There's an organization like ours in every state. In many ways, we're kind of like a legal aid for people with disabilities. We have different sections. So we have a section that does employment discrimination and healthcare appeals. We have a section that does housing work. I supervise our education work statewide, and so we have a team of about 28 people spread throughout Texas who try to assist children and families in getting better special education services from public schools. A big part of that work involves school discipline and fair treatment on behavior-related issues, but we handle other issues within that work as well. And so I love being able to partner with juvenile defense attorneys, and I also love to tell the story of why learning about special education matters. There's probably at least someone in here who thought, why are we going to listen to this, and how does it involve us? I'll say in some jurisdictions, people who practice juvenile defense work cross over and become plaintiffs' lawyers in special education as well. Because cases that you're appointed on, many of them are shooting fish in a barrel if you were to want to sue a school district on behalf of a child with a disability, and you can get money in settlement to do that. I only say that because there is never enough people who know what I know and do what I do to represent the volume of children who need this kind of advocacy that will come through your doors. And so if anything I say sounds at all interesting and it seems like I'm making a pitch, it's that I would love to expand the bar of people who represent children and families in this area of law. One of the things that I love most about special education is when it's done properly, it is a preventative service that is part of the answer to not only keeping a kid from getting in too much trouble at school, but to actually get them the services that might actually help improve their behavior. And so that is one of the kind of few areas of law where we can have that potential impact. So when we talk about what is special education, what's the history of special education, it's important to just know from the very beginning that before 1972, public schools throughout the country basically excluded almost all people with disabilities from public schools. So the initial special education classrooms were volunteers operating in church basements who were trying to prove that children with various behavioral and intellectual disabilities could learn. The education establishment at the time had IQ thresholds, had processes of expelling kids for mental health and behavioral needs, had educatability standards, they said, which was just their way of saying, we promise you really can't teach this kid anything. And parents and families rose up with lawyers by their side and said, well, actually, if you try, you can. And so what happened is a series of lawsuits, most most notably the Park and Mills lawsuits that said depriving a child of access to public school without due process is a violation of the Constitution. Those two lawsuits ended up in a settlement decree that became the federal law that we now have in special education, which is called the IDEA, the Individuals with Disabilities Education Act. So when I talk about the origin of that may seem like too much detail, but the reason it matters is this. It is a law that gives robust due process protections because the original lawsuits were argued under due process. That means that parents who learn enough about their rights and know how to exercise them get something that is actually of benefit in special education. Special education is by no means a guarantee that a child is going to get a good education. We still see the disproportionality of kids in special ed who are referred to law enforcement, who are referred to exclusionary discipline. But the law does have all of the tools to change that dynamic once someone learns how to use them. And so what I've really dedicated my career to, and have an awesome team that does as well, is trying to use the tools of special education to empower low-income families to get the services out of schools that rich ones do. And that's the reality of what we see in public schools. In 1975, we also had Section 504 of the Rehabilitation Act, and then the IDEA, which had a predecessor name that is now offensive, so we won't even use it. But the difference between 504 and special ed is that 504 protects all children with disabilities from discrimination. Special education provides really specific procedural rights and substantive rights to a smaller population of children who, by reason of their disability, also need what we call specially designed instruction. So just a higher level of need. In 1982, we had our first Supreme Court case that kind of answered the question of, do you get more than procedures from special education law? Are you entitled to any quality of education as a matter of law? And in Rowley, they said you do. Rowley was a case of a deaf student who was making all A's and B's, even without sign language interpreters, because she was such a hustler. The Supreme Court said, no, you don't get sign language interpreters if you're making A's and B's without them. So it's what they say is special education's a Chevrolet, not a Cadillac. But the idea here is that in even saying that, what the court did was reject the school district's argument that there was no substantive standard for what quality of education a child was entitled to. So the school districts had been saying this law is procedural only. As long as families got their notice of the meeting, we're good. As long as they had the right people attending the meeting. And the Supreme Court said, no, Congress was trying to do something actually ambitious here. It means more than that. In 1990, we had the passage of the Americans with Disabilities Act, which protected people with disabilities in schools and in public spaces and many other places, that opened the doors of access to jobs for people with disabilities. In 2016, we had the Supreme Court's next review of the Rowley standard for quality of education. And what we had after Rowley was a series of federal courts who basically said, well, you didn't give Amy Rowley the sign language interpreter, so we're going to say that even though there is a substantive right to FAPE, it's just very, very minimum. The Supreme Court reviewed that in 2016 and said courts have gone way off. This was an ambitious law, and a unanimous court overturned the previous decision in that case and said that we have to raise the standard for the quality of education that children with disabilities are entitled to. So the new FAPE standard under the Andrew F. decision in the 2016 Supreme Court was to meet its substantive obligations under the IDEA, a school must offer an individual education plan reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So we have different sources of the law, the federal law, state statutes, commissioner's rules. TEA, for anyone who's interested in this, puts out a side-by-side resource of all three sources of the law, topically organized side-by-side for free that you can download on the TEA website. That on the left is what that document looks like. We put out a parent manual at our office that's available for free on our website in English, Spanish, and now Vietnamese. and that is on the right. That's a much more parent-friendly guide, has sample letters. You meet a client who sounds like they need special ed, but they haven't been referred yet. The parent can tear out a page of our manual and submit it to the school to request that evaluation. So the first thing when we talk about special education is who needs it. Well, the law actually says that school districts have an affirmative responsibility called their child find obligation to find, evaluate, and serve all eligible children aged 3 to 22. Some of you may have remember that the Houston Chronicle had a big story a couple of years back that won them a lot of national awards, an 8-piece series about the Texas Education Agency having an 8.5% cap on the percentage of children who could be served under special education. That was information that they got from our office, but what has happened since that time is that the entire Texas special education system is under oversight by the Department of Education for violating special education rights, primarily by artificially decreasing the number of students served in our state. And so as a result, you're going to meet a lot of clients who had not been identified as needing special education services because approximately 400,000 Texas students were artificially kept out of special education based on TEA's action to save money. And so, unsurprisingly, without the services that they need, some of them end up in your doorsteps with charges. So who is eligible for special education? You're supposed to have a disability, and by reason there, and then also an educational need for specially designed instruction. So the way I remember that is that if I'm maybe a student who is of average intellectual ability, I am using a wheelchair, but I don't need physical therapy, I don't need any other service, I just need to not be discriminated against, I don't need special ed, right? I don't need the teacher to instruct me any differently. I just need to not be discriminated against. I may need some basic accommodations like access to the elevator that students aren't otherwise able to use, but that's about it. So I would be a student primarily protected by Section 504 of the Rehabilitation Act, the other law that we mentioned earlier. But there is no disability category that can't be served under special education if I have a need for specially designed instruction. Specially designed instruction includes behavioral supports. So I can be a gifted child who has serious emotional disturbances and behavioral challenges, and I would still be eligible for special education services if those behavioral challenges are interfering with my education. And so it's important to recognize we're not just talking about students with intellectual disabilities, we're talking about students of all disability categories whose needs rise to that level that they need some specialized intervention. So this is just a graphical illustration of what I just reviewed, which is that those child in the smaller circle are eligible for special education. The larger circle are protected by the ADA and Section 504. Any child who's in special education is also protected from discrimination and has damages abilities under the ADA and 504, but the opposite isn't true because special education is more specific. So this is the Chronicle story I referenced earlier. For any of you who are interested in this issue, it's a great read. Some of the key findings were not only that 400,000 Texas students were kept out of special education, but that it most impacted English language learners. And so whenever you're representing Spanish-speaking students, know that very often what schools have done is blamed all deficiencies on language and haven't even evaluated in areas of disability. And so just something to be aware of. So this shows when in 2004 is when the Texas Education Agency instituted their cap. We see the quick drop from the yellow line is Texas, the blue line is the rest of the U.S. average special education participation rates. And then right after that policy is instituted, Texas takes a significant drop where we lost the 400,000 Texas students. So what that really means practically for you on the ground, not working at a systemic level, but with individual families, is you meet a child who's not yet in special education. The parent can request it in writing. The mistake that 99% of the families make is they're like, I've told the school that the child takes ADHD medication. I've mentioned I think he needs evaluated. I've told him he came out of the psychiatric hospital. but no, he's not in special ed. They won't evaluate. Almost always the parent has orally advocated. They have talked to someone, they have called someone, they have not emailed or made a written request. The law in Texas specifically says that the school must make a decision whether to evaluate within 15 calendar days of a written request. Schools use that pretty readily to ignore oral requests. So if there's kind of one thing you remember in this presentation, it's that if you meet a family whose kid may need evaluated for special ed, put the request in writing. You can find a sample form on the Disability Rights Texas website. After that written request is made, the school has to conduct their evaluation within 45 days, and then within 30 calendar days, they hold the first ARD meeting, which is basically the committee meeting that includes the parent, where we make all of the decisions about what the child's individual plan is supposed to look like. The evaluations have to address whether the student has a disability and what their educational needs are resulting from the disability. It has to look at their educational needs, their related and other service needs. So quick things, you're representing a child with mental illness and they say they're already in special ed. Well, do you get counseling services at school? Probably the answer is no, unfortunately. And so any time that a student is already in special ed, but there's some service that the parent suspects or is willing to accept, but no one's ever mentioned, usually the first step is to say, well, we need a new counseling assessment, or we need a new speech assessment. We need a new assessment on educational issues. Mental illness is often, I think, the thing that's talked about when we talk about behavior. We know that there are high percentages of children in the system who have mental health needs, but what the data shows us is that almost as high a percentage of kids in the system have learning challenges, learning disabilities. And so, why would it be that our behavior rates and our law enforcement referrals are almost as high for a child with dyslexia as they are a child with serious mental illness? And, having academic challenges and not getting what you need to at school can make school awfully frustrating. And so I think it's important to kind of recognize that all of those things can lead to behaviors. It's also good to know that you can have evaluations in the area of behavior. And so one thing that special education has taught me that I think we can apply to so many other settings is that there is actual assessment, science, and interventions to improve child behavior. And so unfortunately, so many of the kids who wind up in the system have never had access to anyone who's ever done an actual assessment of their behavior or provided research-based interventions to address their behavior. And so those are things that can come through special education. So evaluations have to happen at least every 3 years, as often as needed if someone on the committee thinks it needs done more regularly. So maybe the evaluation was done last year, but I have a new behavior that's really interfering with my learning. Committee can come back together and say we need to reassess, do another functional behavioral assessment. Schools are increasingly trying to get away with doing just reviews of existing evaluation data instead of doing full formal assessments. The thing to keep in mind about that is that if a child's doing well, maybe that's okay. But if there's an area of concern, which if they're your client, there probably is, well, then you probably need to do formal assessment to figure out some other interventions that can be provided. One of my favorite things about special education law is that actually allows a parent to get an expert paid for by the other side, an independent evaluation of what their child's educational needs are. So anytime the school does their own assessment, if the parent disagrees with it within a year of it being conducted, the parent can request an independent educational evaluation at school district expense, and the school must pay for a qualified person that the parent chooses to conduct that evaluation and give a second opinion on what interventions are needed at school, unless the school files a lawsuit against the parent to defend their own crappy evaluations. And that very, very rarely happens. And so, You know, so often, for a majority, especially of low-income families, they have been getting the bare minimum of special education services in schools. So the ability to have an independent person who doesn't have any of the conflict that a school district employee may, knowing that, oh, well, if I recommend this service, I may have to be the one to deliver it, can come in and make really robust recommendations, which can be the basis of a lot of change. So all of the decisions, the evaluations, the planning are reviewed by the admission review and dismissal meeting. That has to happen at least annually, but a parent can call one anytime they have a concern, as can the school. A parent's supposed to be given 5 days notice, and they're supposed to work with a parent's schedule. You know, I have a colleague here in the room, Sarah Beebe, who runs a special program for a Harris County probation department. And the county has actually done a very progressive thing of contracting with our office for education advocacy for kids who are already in the probation system. And so these are kids after you're done with them and they are fully in juvenile probation. And the reason they've done that is because we're often able to advocate for those youth in a way to make them more successful in their probation, to help them re-enter after they leave detention facilities and be successful. What I hear from Sarah and her team a lot is probably not surprising to any of you, that many of these families struggle with barriers to be an active participant with their child's school, right? And so it's really our job to encourage those parents, to encourage schools to work around those parents' schedule, but to kind of remind people that these are some of the things you can do as a parent that can change the trajectory for your child. If the child has been referred to juvenile probation several times, and it's usually for something that happens in school, getting involved in that school advocacy piece is likely to be most successful. Yes? Right. You know, I think that you can just, so the comment was that they've had experience with school districts who delay their own personnel showing up to the meeting when the parent essentially doesn't have enough time to wait around. That happens. I think the main thing you can do is always kind of create a paper trail of documenting that this happened last time. The parent has a work schedule that can't allow this in the future. We're now going to need to schedule the follow-up meeting at a time, you know, around the parent's schedule. I think the mistake that parents make is they think it's the school's way or the highway, and if I can't come to this meeting, I'll just kind of not respond to the invitation. And if a parent isn't responsive, well, then the school can go forward with the meeting. But if a parent communicates, I want to be at my kid's meeting, but guess what? I cannot come before 5 o'clock. Then arguably the school may need to do it after 5 o'clock. And so those are just things to keep in mind on that. So the committee meeting has to include the parent, a teacher, a special ed teacher, a general ed teacher, a person qualified to review evaluations, and a school administrator who has the ability to be knowledgeable of district resources and the authority to commit district resources for the child. An individual education plan, which is established, has to provide everything about how the child's doing, what goals, accommodations, placement they need, behavioral intervention plans, related services, transition services. You know, one thing to keep in mind is that only after you determine what a child needs should you talk about the child's placement. Know that school districts under special education have to provide a continuum of placement that includes residential placement when necessary. And then the assumption is that at the bottom of the pyramid, the majority of children receiving special education would be accommodated in a regular classroom like anyone else. But some people aren't knowledgeable that a school district is ultimately responsible for providing whatever that child needs on that continuum. So school discipline, and we're running a little short on time. So despite the strong protections in the law, we do have an over-referral of children with disabilities who sometimes struggle with behavioral challenges to all forms of exclusionary discipline. It varies drastically by district and even more drastically by campus. And so when we look at disproportionality of special ed referral, we see that there are districts that, like Aldine, who don't have a great amount of disproportionality in their removal, and then other districts like Klein who are referring about 3 times as many students in special education to alternative settings as they exist in the school population. One thing that we have in Texas, if you're interested in the policy around discipline, is the Breaking School Rules report by the Texas Council of State Government, the Council of State Governments. And what they actually did a longitudinal study over about 7 years, looking at several million Texas students with all of the data points that TEA collects on those children. So they were able to hold constant variables of income and many other things, and still found huge disproportionality both in discipline and race. So schools have to consider all factors in disciplinary decisions, but the stronger federal law, and I'm kind of moving fast because of time, is what the federal law says on removals of over 10 days. I want to get to this because very often the same offense at a school that would lead a child to be referred to juvenile justice is likely to lead to an expulsion decision at school or removal to what we call a DAP, or disciplinary alternative education placement. Whenever a removal of more than 10 days is recommended, no matter what kind of removal it is, any disciplinary removal, the school district has to convene the ARD meeting and answer 2 questions. The first question is, was the conduct caused by or had a direct and substantial relationship to the child's disability? Or was it the failure of the school to implement the student's individual education plan? If the answer to either of those questions is yes, then the student is not sent to the disciplinary setting unless the conduct involved drugs, weapons, or substantial bodily injury. About 98% of the removals in the state of Texas do not involve one of those exceptional items. And so for most referrals, if the conduct was caused by the disability, then the child's not supposed to be removed to the alternative setting. I think one thing that's important as a juvenile defense attorney to know is that even though this is a little different standard than you would use in a criminal context, it's pretty relevant. So if you had a group of professionals who know a child, including a school psychologist, sit around in a meeting and decide that the conduct was related to the student's disability, that's pretty helpful to know about, right? And so know that if you have a child who is being referred for a school offense, hey, were they also sent to a disciplinary setting at school for this? Did y'all have the meeting to decide if it was related to disability? If the connection is found to disability, or if the child needs it because of just struggles with behavior at school, they can do a functional behavioral assessment. A quality functional behavioral assessment is conducted by a highly skilled person. The gold standard is a board-certified behavior analyst. I bet that no more than 10% of you have ever had a client who has access to highly qualified BCBA to evaluate their behavior and make recommendations before. And it also includes observation, so not just a review of records and interviews with teachers, but also directly observing, capturing data, and making recommendations. So we are about out of time, so there's more detail in the PowerPoint related to some of those decisions, but I'm going to end with 2 things. One, there's a lot of people who are intimidated about going to an ARD meeting or just coaching a parent. The number one thing about an ARD meeting is you can't do it wrong unless you pretend to agree with the decision at the end that you don't agree with. So I always tell the parent to have their convictions when they go into the meeting. They're going to be out-credentialed and outnumbered, but if they believe in their heart that their child's not being treated right, they need to raise their concerns, and they need to disagree at the end of the meeting if they are not pleased with what is offered to respond to their concerns. That's a great time to then call Disability Rights Texas. When a parent has tried some advocacy on their own, it hasn't been quite enough, I will also say that once we get involved, instead of going to ARD meetings, our real preference is to file complaints and lawsuits. And so special education law allows the power for a parent to be reimbursed if they're successful in due process, which is an administrative hearing. It's fairly formal. It's usually a 3-day hearing. In 95% of the cases settle, and they can settle with fees. If anyone in here wants to learn how to do one, email me or get in touch with me, and we can kind of coach you through that. I'll also say that if you're not interested in doing it yourself, but you have a client who you would really like to get into our office, don't hesitate to reach out to me. Now, when I say that, this is a pretty big room, and my office is not huge. And so what I mean by that is, like, save it for the kid who's really being messed around at school. You know, one that you're just very concerned about, either the nature and extent of their disability or just how bad the facts are. Feel free to reach out to me directly. You can refer any parent to Disability Rights Texas. Our intake information is on our website at drtx.org. We also have someone answering phones 5 days a week to take requests by phone as well. So I think we're out of time, but a pleasure to be here. And if you have questions, catch me or my colleague Sarah, who's here in the front row. Thank you.
This is Dr. Uche Chibueze. And let me tell you about Dr. Chibueze. If anybody that does juvenile work obviously knows who Dr. Chibueze is, and if you're going to be doing juvenile work, you need to know who Dr. Chibueze is. She is a board-certified clinical psychologist, received her doctoral degree in clinical psychology from Texas School of Professional Psychology in 2009. She also has a master's degree in community counseling from Baylor University. She completed her predoctoral and postdoctoral internships with the Harris County Juvenile Forensic Unit, which is here in the. It's not part of the. It's part of the probation department, but it's a independent unit of the probation department. They have a contract with the probation department. Dr. Chibueze also conducts, this is how we know her from both sides, the state and the defense, is when you have certifications, she conducts those clinical evaluations, the forensic evaluations for the waiver to adult court, for fitness to proceed evaluations, and for lack of responsibility evaluations. And I will say, let me just put a little note in here before I say some more scholarly things about her. She has this amazing ability to get through to the youth, the youths. I have seen her with some of the toughest kids, and I don't know if you took a course in teenage lingo, but she knows all the latest stuff that these kids know. And so when I'm with lawyers sitting in the room, and I'm sitting in the back of the room in the evaluation while she's doing it, and she sees a kid that's just shut down, she starts throwing some stuff out, and all of a sudden that kid perks up, and you realize I've got someone that understands my language, and then they're conversing, and they have I've never seen her not do a successful evaluation with a child. She's just too likable, and she knows how to really break through to these kids. So that's a testament. And we have some other great doctors down here, but you have a special talent for that. She also provides expert witness testimony on a continuous basis for the juvenile courts. So if you've been up there, you've seen Dr. Chibueze testify in all 3 juvenile courts. And she, you know what? Balls and strikes. This is a impartial forensic, which is what forensic evaluation is supposed to be. Balls and strikes, calls it right down the middle. She does not have a dog in the fight, whether it's for the state or the defense, calls it just like she sees it. This is what's interesting. She's conducted research that explored the impact of the acculturation process on African immigrant families, and also created one of the first clinical measures geared specifically for the African immigrant population. In addition, she's provided presentations on mental health issues affecting the black population for the American Psychological Association and Texas Psychological Association at their annual conferences. She provides trainings on projective testing. She's presently working on researching mitigating factors associated with waivers to adult court evaluations. It is an honor to have Dr. Chibueze here. Thank you.
You make me sound really fancy. I'm not that fancy of a person. Thank you guys for being here today. I know you guys are tired. 30 more minutes before happy hour, so we'll get you there, hopefully in one piece, okay? So today, I'm going to spend my time talking about the services that are provided by the forensic department and also the services that are provided by the psychological department as a whole. I am a little bit more impartial to the forensic department because that's where I work, so I'll spend a little bit of time there. And then on the back half of our presentation, we'll talk about the interventions that our department does provide as well. Okay? All right. I don't know what happened. Okay. So tomorrow you'll get the opportunity to meet Dr. McGill if you have not yet. Dr. McGill is our deputy of the Health Services Department. And the Health Service Department includes assessment and treatment interventions. Okay, you guys are all attorneys, right? So why would you care about services for our kids? You guys are attorneys, right? Not psychologists? Well, obviously we do know the juvenile court is, in theory, supposed to be rehabilitative in nature, okay? All right, so hopefully we're going to put that into practice. So what we're trying to do is provide services so the kids don't come back. All right, that is the nature of what we do here. And so we do have services that we find that hopefully can decrease recidivism as a whole. So I do feel as attorneys it's important to understand or have an idea of what services are available in our jurisdiction. Because these are things that you would want to recommend, of course, whenever you are working with a youth. So things that we have in our department, it's a very vast department. We have medical services. We also have the forensic department. We also have MST. Anybody heard of MST? Yes, we do have MST as well. Triad, Parenting with Love and Limits. We also have specialty courts. We have 4 specialty courts. I'm not going to go into too much detail about the specialty courts because you will be getting a specific presentation on that tomorrow by Dr. McGill. Also, different provider services that are within our placement facilities and also services that are outside of our placement facilities as well. So I want to take the first half talking about assessment. Let me talk about what I do. I am the chief psychologist of the forensic department. And what Halpert actually was mentioning is that we are a separate entity, and that is true. Okay, so a lot of people think that we are part of probation because we are housed on the 4th floor. But actually, most of us are Harris Center employees. Okay, and there's a reason for that. The reason being is that we're not linked to probation, so we don't have a dog in the fight as to whether we think a kid is fit to proceed or not, or whether a kid should be waived or tried in adult court or remain in juvenile court. So it's intentional that we are a part of the Harris Center so that we are not connected, if that makes sense. Okay, so sometimes it may be confusing. If you see me in court, most people will think I work from probation, but technically I do not. Okay. So our forensic department is quite vast. Like I said, I'm the chief psychologist of the forensic department. We also do have our director, which is Mary Martinez. And anybody get a chance to meet Mary Martinez? She's a lovely lady. She likes to chat. So if you come up to the 4th floor, she'll definitely engage you and ask you a lot of questions. All right, but she is our director. We also have Dr. Dorsey. She is in charge of our internship program. So you may notice that in our evaluations, you may see some random names. And the reason why you may see some random names is because we have interns that come from all over the country. And they come and learn how to do these evaluations with us. And so that training program is led by Dr. Dorsey. Okay, so in our department, we have 3 psychologists. We also have a board-certified psychiatrist. And our psychiatrist, she's board certified in both forensics and child and adolescent work. So she has got extensive history conducting evaluations for the juvenile court. I think she's worked for us almost 30 years. So it is a long time. Okay. We also have 4 master's level clinicians and 3 doctoral interns and a lot of practicum students. So we do have students from all over Houston that come and train with us as well. So we conduct about 1,376 screenings a year. We also conduct about 592 full psychological evaluations a year, too. So there's a big output that our department is responsible for. And also 289 psychiatric evaluations. That's all Dr. Whittick by herself. So that's a lot. I do want to talk about the different kinds of evaluations and when you would want to order certain ones. The most common one is a psychological screening. Sometimes we call it a JET. Now, this is something that was an agreement that was made with the defense attorneys, is that we do a quick and dirty clinical interview with every youth that is detained in our facility. We also do a quick IQ and a quick achievement test. And from there, we provide recommendations. That evaluation takes about an hour, and it's not really in depth, but it just lets us have an idea of what's going on with that kid. Okay, so every kid that is detained will get this kind of evaluation. Unless you specify you do not want that kid to be seen. Now, there are some situations where it's like a media case, where you don't want the kid to be seen, like if it's a capital murder, things like that. You may elect for your youth not to have that evaluation. When kids have more issues going on with them, then we sometimes do what's called a full psychological evaluation. That full is really more in depth. So you'll see that evaluation would be about from 10 to 20 pages long. And that's when we're systematically evaluating what's going on with the youth and coming up with a diagnosis and specific recommendations. Also, we mentioned we have a disability, determination, intellectual disability, fitness to proceed evaluations, lack of responsibility, and certification. So my understanding, you guys have already had a presentation on fitness to proceed and LORs today. Do you feel we fully understand it? No? I do have a question for you guys. Something that we came up with in our training process is that we thought maybe we can provide a little bit more trainings on lack of responsibility and competency evaluations. I just want to get an idea if anybody would be interested in that, if we were to talk about it. Yes? Okay, all right. Because we literally were just kind of kicking that idea around. So maybe next year we may have some interns that will provide some seminars. So if that is something that you guys are interested in, then that's something we'll try and put together. Okay. All right, so the goal of our evaluation basically is to collect data with a psycholegal question. Now, in forensics, as forensic psychology, it's not a perfect marriage. And those of you guys that do that question us on the stand, you can get annoyed with us. All right, it's a lot of times they're like, why can't it be an exact science? Or why can't you give me a straight answer? All right. So it can be quite annoying. And that's partly because we operate in the gray and you guys are very black and white. But we can render some opinions that could be very helpful to you. We also provide information about education and adolescence. Those of you guys that are doing juvenile work, you notice how juveniles are different from the adults, right? And that's regular juveniles that don't get involved in the court. So those certain things that we need to highlight that are specific to juveniles that are brought out in our evaluations. We also talk about treatment needs, and we can also provide court testimony as well. So we can also be subpoenaed as well to provide testimony if you are needing that. Every youth that gets evaluated, it's in our facility, they also get staffed. Meaning that there is a team of different professionals that come together and we look at the evaluations, we look at school reports, we look at probation, and then we render a judgment whether the kid should be detained or whether the kid should receive services in the community. And that comes from their daily staffings as well. And when we're doing evaluations, things that we look at, we talk to the youth. Every kid that we see, we do try to do an interview. We try to talk to the parent. We think that's very important. We also try to talk to any teachers, get school records, and then also testing. So I do want to talk about what goes, I think I talked about the JET a little bit But when we're doing a full psychological evaluation, it could be for different referrals. Sometimes I may have a kid that's here for a serious offense. Lately, we've been getting a lot of kids for school threats. And so you may ask for evaluation to see how much of a threat that this kid poses to the community. Also, you may have an evaluation to determine whether the kid has an intellectual disability, which is very salient when you're talking about fitness to proceed. So when we do those, we do some comprehensive IQ tests. We can do RAT testing. We also do personality testing as well. In the fitness to proceed, everybody understands the difference between fitness and lack of responsibility? Yeah, so fitness is here and now, and then lack of responsibility speaks at the time of the offense. So I may have a kid that's responsible, but it's not necessarily fit to proceed, and vice versa. So we do those evaluations by doing a clinical interview. We also specifically look at factors that are associated with DUSKI that lets us know the person understands what's going on in court, has appreciation, and can assist in their defense. Something I always get asked this a lot. Just because a kid has an intellectual disability doesn't mean necessarily that kid is not fit to proceed. So sometimes I see attorneys tell me, wow, this kid has a 50 IQ. There's no way he or she can be fit to proceed. But a lot of times what we're looking at is really specifically the prongs of DUSKI, not necessarily the IQ. But that helps open the door. Fitness to proceed evaluations can only be done by a licensed psychologist or a psychiatrist. And so you'll see it's either done by myself or Dr. Wittig or Dr. Tellez. Okay, so lack of responsibility speaks to the time of the offense. If a kid, this is a question that comes up a lot, if a kid gets found not fit to proceed, we do not do the lack of responsibility. Okay, so we address fitness first. All right, so that's something to keep in mind, because if a kid is not fit to proceed, then they can't enter a plea of not guilty by reason of insanity, which is the adult service. So for that reason, we cannot assess lack of responsibility. So sometimes I see an order for both, but if you see that we don't do the LOR, the kid is not fit to proceed, the reason being is because of the fact that we want to address fitness first. Any questions on that? Yes. For the most part, no, but there are some instances we'll get a kid right away and we'll test them the next day, and we may not have an attorney on record. Typically, if it is a capital murder, we will not do the JET, though. Any other questions? Go ahead, sir. Okay. That's a whole different presentation. He asked, is there a child that cannot be successfully rehabilitated? That is actually a question that we try to speak to when it comes to the waiver evaluation. You will not see us render an ultimate opinion about that, but we may talk about his treatment amenability. And we'll look at factors that say whether this kid has a higher likelihood of being amenable as opposed to a lower likelihood. I'm trying to understand your question. So you're asking what else do we do for those kids? Evaluation-wise or treatment? If they're over 18, so sometimes we get this where the kid committed the offense as a juvenile but doesn't get caught until they're an adult. Usually what happens is that there's evaluation for waiver to adult court at that point. But whenever they're over the age of 18, a lot of the factors of Kent don't apply. So you may not see us render an opinion regarding dangerousness, sophistication, or treatment amenability because of the fact that they can't be served in our jurisdiction after 18. So the only thing that we do in those situations is talk about the kid's background history. We talk about nuances that could affect treatment amenability and outcomes. Yes, so we won't do anything with that case until we determine jurisdiction. Yeah, so I'm thinking of a specific case that we just did for you recently. Okay. Yeah, so in that situation, once again, we'll do the full evaluation for certification purposes. But if you look at the family code, it does state once the person is over 18, then we won't necessarily look at moon factors because they're not salient at that point. So instead, we'll just do a full psychological, and then the court will determine jurisdiction, and that's it at that point. Any other questions? These are good questions. Okay. Now, you did ask me earlier, can we testify regarding the brain at the time of the offense? Is that what you're speaking to? Yes, okay. Yes, we can provide testimony for different things. Anything that has a psychological nature to it, we can. And so in your specific instance, the offense happened when the person was, I think, 11, and you want us to speak to that person's potential state at that time. You could speak to that to a certain degree, yes. So yes, so lack of responsibility. We do those evaluations, and then testimony is available for that too. We also sometimes get called. Sometimes you may have competing experts. So we may do our evaluation, and of course, as defense counsel, you can request your own evaluation. If you do request us, then that's not work product. Okay, so that is something that cannot be suppressed. So sometimes I do find that defense attorneys will request their own evaluation because then it's considered to be work product at that point. Okay, but if our department does it, it's going to be part of the record. And something to keep in mind too, when we do the lack of responsibility, we do talk about the offense. So just keep that in mind. If you don't want that offense to be anywhere on the record or us to talk about it, then you wouldn't raise the issue of an LOR. Okay. Just what the gentleman was talking about, certification. We do this evaluation commonly, not as much as we used to. There was a time we were doing a lot of certifications, a lot. I actually went to a conference once in Atlanta, and we were all talking about how many certification evaluations we've done. And Kirk Hilburn is one of the biggest names in psychology when it comes to certifications. And he asked me how many I've done. I said over 100. And he was like, "You've done more than me." I'm like, well, because Harris County, at one point, I've been around since about 2008. There were a lot of certifications happening, and more than the average county. So we were just getting a ridiculous volume. I do find now this has gone down quite a bit. But the things that you can benefit from if you were to do the evaluations is that we look at the Moon and the Kent prongs, right? So we look at sophistication, maturity, treatment amenability. I do find that attorneys find the most value when it comes to treatment amenability and dangerousness. Okay, so we systematically look at that by using the risk sophistication treatment inventory, which is one of the only measures that was specifically made to look at certifications. Okay. In those evals, we also look at IQ. We also look at achievement, and we do some personality testing too, and a clinical interview. Obviously, you guys always have the option to sit in on those evaluations. Does everybody know how to order an evaluation if you want one? And how to schedule one? Huh? Mary, yes. I call her the Godfather because she runs things. And she knows everybody, and she knows everybody's business. But no, I'm not even joking. But yes, she is the person that you would email anytime that you want to set up evaluation. When we get an order, what happens, she looks and she will call you guys, and she would ask, would you like to be present or not, or if you waive being present. So definitely respond to her, and we try to set it up in a way that you can be present for that evaluation in person too. Also, Christina's our administrative assistant, and she's really great too. I do want to talk about another person. Most of you guys are probably familiar with Michelle Blunt. Yeah, she was the court liaison for the longest. For now, we do have a new person named Deidre Ewan, and she's the one that's handling if a kid is found not fit to proceed, or there's a lack of responsibility issue. She's the one that's handling the referrals to the state hospital. She's also handling the referrals to HCPC as well, so that's a good name to know now. She's basically the new Michelle Blunt. She's new. She literally just started like a month ago. So yeah. And do we understand the process if there's a finding of not fit to proceed, what would happen next? That you guys well went over that earlier today. Thank you, Hans. All right, you make my life easier. Okay, but she's also the person you would want to contact for that. Any questions about evaluations as a whole or services that are provided by the forensic department? And so earlier in the presentation, I do have my email too. If you have questions, feel free to email me. We are located on the 4th floor. You can come on up, and if I'm available, you can come talk to me. My extension is 4303. I think it's 24303 because we just got new phones, which is unnecessarily complicated. Okay. I do want to spend the last half talking about the treatment services that our department handles. Our forensic department as a whole, we don't provide treatment. We separate that, and there's a reason for that. Because if you are an expert witness and you also provide treatment, it makes it difficult for you to not be biased. So that's something to keep in mind, that myself, Dr. Tayez, and people like that, we are not providing treatment so that we can stay in that expert realm. Okay, so psychological services. The director of psychological services is Kim Richter. Basically, any kid that comes in with any kind of medication history will automatically be evaluated by psychological services. Also, any kid that pops out positive on the MACI, which is the computer test every kid takes upon intake, and it shows like maybe if the kid is suicidal or have aggressive tendencies and things like that, or maybe unstable, they are going to be evaluated by psych services as well. We also do medication management for psych services, so the psychiatrist that is responsible for that is Dr. Mateen. Okay, so she's different from Dr. Wittig. Dr. Wittig does the evaluation, Mateen does the treatment. They also have therapists that check in with the youths as well and provide brief therapy. We were very excited about this. About maybe 3 or 4 years ago, HCPC was a place that we used to send our kids that are not necessarily stable. That closed down because it was a very expensive program. Well, now it's back. So anytime we have a kid who we feel has a subacute issue, we can send them to HCPC for stabilization. Okay, so if you happen to meet a kid and they're in a facility and we have not seen that kid yet and you do have concerns regarding their psychological stability, just let us know. We can try and assess them to be seen by HCPC. The things that the kids that we're not allowed to send to HCPC are the ones that are there for capital offenses. If it's a sex offense, it's a case-by-case basis, because if it's a sex offense, we have to keep them in their own room. So it's based on availability. And also eating disorders, but you guys don't have to worry about that. So Dr. Madera, she used to be part of BBRC and our facilities. She is now the clinical lead at HCPC. If you want to recommend a referral, Deidre Ewan is also in charge of that program as well. We also have treatment programs in our facilities. Things may be changing soon, but for now, one of our facilities would be Youth Village. We have a trauma program there. So any kid that's experienced significant trauma that's impacting functioning, if they're a boy, they can go to the Boost program. And if they're a girl, they can go to the GIFT program. But usually they have to have some kind of documentation of trauma that is significant enough to go there. And they like more so like sexual trauma or like physical trauma and things like that. We also have field services. These are youths that, of course, are put back in the community. They can receive counseling services through the CUPS units. And we have plenty of therapists that are out there that provide individual counseling, group counseling, and family counseling as well. That is led by Dr. Tayez. SNDP, these are kids that have some psychiatric issues that require wraparound services. So that provides them therapy and also provides them access to a psychiatrist as well. A lot of times, if they're in our catchment area, we can send therapists to the home. Typically, if they're outside of the Beltway, we can't service those kids. We also have a partnership with the Harris Center. This is especially for kids that are intellectually disabled, where they can provide services and they can get access to a specialized IDD JPO. We also have a sex offender program, which is located at BBRC. It's called a SEEK program. It's led by Lindsey Brown. And these are youths that are found that are adjudicated of a sex offense. Now, sometimes there's a request for a risk assessment for sex offenders. We cannot do those risk assessments prior to adjudication. Okay, so those are conducted after the kid has been adjudicated. You guys mentioned that you are familiar with MST. MST is one of the best evidence-based programs for youth that act out. So we do have an MST program that is led by David Tristan. They also have therapists that are on call 24 hours a day that provide services for the youth that are referred to the program. The thing about MST, it's usually impacting the parents. So we help out with the parenting and give strategies on how to handle delinquent youth. Parenting with Love and Limits, I understand that this may have changed the name, but it's not confirmed. But it's a great service that we provide. Kids that also have issues with communicating with their parents or delinquent behavior that the parents are unable to handle. In PLL, they work with the parents and they work with the kids, and then they come together as a whole. So this is something new, too. A lot of our kids have CPS involvement. And so we do have now a dual status initiative where we have a specific program for kids that are both juvenile justice involved and kids involved with CPS as well. I think you guys had a presentation on that earlier today, too? Or tomorrow? Tomorrow. Okay, so I won't go into too much in depth. I don't want to steal their thunder. But I think it's a great initiative just because there is a huge overlap between our two populations. So there's specific services that are provided to them. And this is led by Allison McGallion. And then we do have our 4 specialty courts. Like I said, I know you guys are going to get more information about that tomorrow. There's GRIP Court, which is Gang Court, and Drug Court SOAR, which is led by Dr. Sylvester, and Care Court, and now Court 360, which used to be Mental Health Court, that is led by Dr. Nelke. Any questions about services that we provide? Yes, sir. So the gentleman asked about rehabilitative services for TJJD youths. Okay, so it just depends on which campus they're sent to. If they're sent to get-ins, they can be part of the capital offender program. So sometimes we have kids who are not waived or not tried as an adult and kept in the juvenile court. They can get that service there, which is specific for capital offenses. MART is has more of a mental health services, so kids that are not necessarily psychologically stable will get psychiatric services out there in MART. Now, these are not probation. Sorry, this is TJJD, so that's more of a state service. So that's not what we provide. Okay. I think I'm out of time. Oh, no. Somebody didn't turn their phone off. Okay. All right, any other questions before we... Thank you, guys.